In January of 1997, Justin Sneed beat Barry Van Treese to death with a baseball bat. Sneed was the maintenance man at a best budget inn located in Oklahoma. Van Treese was the owner of the inn. Following the gruesome killing, Sneed was taken into custody and interrogated by police. During his interrogation, Sneed confessed that the murder had been carried out at the behest of Richard Glossip, a manager at the best budget inn. Glossip was charged and convicted of murder and sentenced to death. Throughout his trial, Glossip maintained his innocence and opined that Sneed gave a false confession in order to escape the fate that Glossip had been sentenced to. In August of 1997, Shonda Waller returned home from a grocery shopping trip to find her 11-month-old daughter lifeless and without clothes. The infant was rushed to the hospital where she was declared dead on arrival. She had suffered a fractured jaw, skull, and ribs. A number of her organs had also sustained injury. A nurse at the Mercy Hospital in Oklahoma suspected that Waller's daughter had been sexually abused before her death, leading investigators to Charles Warner. Warner was Waller's boyfriend and was alone with the 11-month-old while Shonda was shopping for groceries. He was charged and found guilty of rape and murder of the infant girl, for which he was given the death penalty. In June 1999, 19-year-old Stephanie Neiman and a friend planned on visiting their friend Bobby Bornt at his home in Perry, Oklahoma. Unbeknownst to them, Bornt was inside his home, but he had been tied up and beaten by 3 men: Clayton Lockett, Alfonso Lockett, and Sean Mathis. Bornt owed Clayton money, so the 3 men had broken into his home to take what they believed they were owed, while Bornt's 9-month-old baby lay in an adjacent room. Stephanie and her friend, unaware of the violence occurring inside, stepped into the home. They were greeted by Bornt's assailants, who tied them up. The 3 men repeatedly raped Neiman's friend before placing Neiman, her friend, Bornt, and Bornt's child in the back of Neiman's truck. Lockett and his accomplices drove the terrified group to a remote area. At this point, Neiman promised Lockett that if she was freed, she would go straight to the police and tell them what he had done to her and her friends. In response, Lockett brandished a 12-gauge sawed-off shotgun and shot Neiman from 6 feet away. Neiman's bluster was not diminished, and she refused Lockett's orders to keep quiet. Lockett then ordered Mathis to bury Neiman, despite the fact that the 19-year-old was still alive. Bobby Bornt, the 9-month-old baby, and Neiman's other friend could do nothing but watch as Stephanie was buried alive in a shallow grave. Lockett released his remaining 3 captives under the threat that they would be killed if they went to police. Despite the threat, the teenagers went to the police upon their release. Clayton, Alfonso, and Sean were arrested shortly thereafter in connection with the murder of Stephanie Neiman. Lockett was convicted of murder, rape, forcible sodomy, kidnapping, assault, and battery, for which he was sentenced to death, while his accomplices were both given life. Lockett was slated to be executed by the state on April 29, 2014. Prior to 2011, death penalties by lethal injection used a mixture of sodium thiopental, pancuronium bromide, and potassium chloride to kill inmates. Sodium thiopental is a barbiturate that sedates and renders inmates unconscious. Pancuronium bromide is a muscle relaxant that paralyzes the inmate, and potassium chloride sends the inmate into cardiac arrest, killing them by heart attack. The pancuronium bromide is administered in such a high dose that, if the inmate did not die from the dose of potassium chloride, the pancuronium bromide would induce asphyxiation and they would choke to death. In 2011, however, the manufacturer of sodium thiopental, Hospira, announced that it would stop producing the drug because of its use in lethal injections. This led to a shortage of a drug required to carry out executions, and states scrambled to find alternatives. Oklahoma's solution to this problem was to use midazolam instead of sodium thiopental, vacuronium bromide instead of pancuronium bromide, and would continue using potassium chloride. Midazolam is a benzodiazepine that would sedate the inmate similarly to sodium thiopental. However, Oklahoma's dosage of midazolam was 100 milligrams, a dosage that had not yet been tested in humans. Florida, by contrast, also used midazolam in their executions, but they administered it in dosages of 500 milligrams. Even though Oklahoma's mixture of drugs were untested in their dosages, the state decided to move forward with its executions. At 5:50 a.m. on Lockett's execution day, prison staff attempted to X-ray Lockett, but this was delayed due to Lockett's refusal to be restrained. Lockett was tasered as a result, and the staff proceeded with the X-ray, during which they discovered that Lockett had a self-inflicted cut on his arm. The cut was determined to be non-serious at 8:15 a.m. Lockett's execution was scheduled to take place in the afternoon, but execution staff had difficulty establishing an intravenous connection. Lockett had been purposely dehydrating himself leading up to his execution, making his veins harder to pinpoint. Additionally, the execution staff did not have the correct size of needle, and they did not have tape to secure the needle to Lockett. 2 attempts were made at inserting the needle in Lockett's left arm, but both attempts failed. Another attempt was made in his left bicep. 3 failed attempts were made in his jugular vein. A failed attempt was made in his subclavian vein and his left foot. The doctors were finally able to insert the IV in Lockett's femoral vein in his groin. Midazolam was administered at 6:23 p.m., and he was declared unconscious 10 minutes later. Vicuronium bromide and potassium chloride were then injected. At 6:36 p.m., the scene in the execution room became chaotic and confused when Lockett began to thrash violently and the death row inmate complained that something was wrong and that the drugs were not working. All of this culminated in Lockett attempting to get up from the execution table at 6:37 p.m. The execution was halted at 6:56 p.m., and Lockett suffered a fatal heart attack at 7:06 p.m., nearly 40 minutes after the execution began. The botched execution led to massive public backlash, and an investigation was conducted to determine what factors contributed to the massive failure. According to the investigation, Lockett's femoral vein had collapsed, causing the fatal drugs to absorb into surrounding tissue instead of circulating throughout his bloodstream. Medical staff were unaware of the collapsed vein because they placed a cloth towel over the area to conceal his groin. Following the botched execution, the state of Oklahoma granted a 14-day stay of execution to death row inmates while they investigated the incident and made adjustments to their execution protocol. With executions being momentarily paused, Charles Warner, who was supposed to be executed hours after Lockett, Richard Glossip, and 2 other death row inmates petitioned a federal district court to enjoin Oklahoma's executions on the grounds that the use of midazolam in execution constituted cruel and unusual punishment in violation of the Eighth Amendment. The federal district court judge denied the motion, holding that the inmates could not prove that they would succeed on the merits of their claim, which is required in order for a judge to grant a preliminary injunction. The district court judge also held that the inmates had failed to provide a known and available alternative to midazolam. The death row inmates then appealed to the 10th Circuit Court of Appeals, who also denied their request for preliminary injunction. They then appealed to the Supreme Court of the United States, who declined to hear the case. Subsequently, Charles Warner was executed. Warner's autopsy revealed that he had been killed by potassium acetate, not potassium chloride. Potassium acetate was not part of Oklahoma's lethal injection procedure, and in fact, Richard Glossip's execution had been postponed in the past because the state only had potassium acetate on hand, not potassium chloride. Following the execution of Warner, Glossip and 2 other inmates repetitioned the court to hear their case. This time, the court agreed. Oral arguments were heard by Chief Justice John Roberts and Associate Justices Antonin Scalia, Anthony Kennedy, Clarence Thomas, Ruth Bader Ginsburg, Stephen Breyer, Samuel Alito, Sonia Sotomayor, and Elena Kagan. Robin Conrad, the counsel for Glossip, summarized the bulk of her argument in her opening sentence when she said, quote, "Oklahoma chooses to execute our clients with a 3-drug formula that includes a paralytic and potassium chloride, drugs that cause intense pain and suffering. The second and third drugs are constitutional only if a prisoner will not feel pain and be aware of the suffocation caused by those drugs. The district court erred as a matter of law and as a matter of fact when it found that midazolam, as the first drug, is constitutionally tolerable." Unquote. Glossip's argument that midazolam will cause pain and suffering prohibited by the Eighth Amendment hinges on the facts found in the district court. The district court found that midazolam does a sufficient job at preventing death row inmates from feeling the pain of vicuronium bromide and potassium chloride. That is why the district court denied Warner and Glossip's original motion for preliminary injunction. The appeals court affirmed the decision of the trial court based on the facts found at the trial court. Now in the Supreme Court, Glossip is arguing that the facts found in the district court were completely and factually erroneous, and that if the facts are actually taken into account, the Supreme Court will find that midazolam does not in fact reduce pain as the state says it does. Justice Sotomayor gets to the heart of this argument when she asks Glossip, quote, "So what are the clear errors in terms of the reasoning and that the district court used?" Unquote. To which Glossip responds, quote, This drug midazolam is in a different class than barbiturates. This drug is not known, it's not a pain reliever. The district court recognized these two facts. It's known that this drug has a ceiling effect, so there's a certain point at which giving more of the drug is not going to matter. The district court recognized that. The state's expert recognized that. The petitioner's experts recognized that, unquote. So again, Glossip is bringing up facts about midazolam, namely that it does not prevent an inmate from feeling pain as the state claims it does. Glossip argues that these facts were ignored in the opinion of the district court, who handed down a ruling that Glossip believes to be without any basis in the scientific fact and pharmacological reality of the drug. Justice Alito brings up the controversial history of midazolam and its predecessor drug, sodium thiopental. For Alito, he believes that those who want to abolish the death penalty are pressuring manufacturers such as Hospiro to stop making drugs like sodium thiopental in order to force states to use drugs that are riskier, thus increasing the likelihood that the court will find a method of execution unconstitutional. This Justice Alito finds unacceptable, and he calls it a guerrilla war. More specifically, he says, quote, "Executions could be carried out painlessly. There are many jurisdictions in this country and abroad that allow assisted suicide, and I assume that those are carried out with little, if any, pain. Oklahoma and other states could carry out executions painlessly. Now, this court has held that the death penalty is constitutional. It's controversial as a constitutional matter. It certainly is controversial as a policy matter. Those who oppose the death penalty are free to try to persuade legislatures to abolish the death penalty. Some of those efforts have been successful. They're free to ask this court to overrule the death penalty. But until that occurs, is it appropriate for the judiciary to countenance what amounts to a guerrilla war against the death penalty, which consists of efforts to make it impossible for the states to obtain drugs that could be used to carry out capital punishment with little, if any, pain? And so the states are reduced to using drugs like this one, which give rise to disputes about whether, in fact, every possibility of pain is eliminated." Unquote. An interesting argument to be sure, and certainly a different way to look at the situation that could potentially alter the opinion of the court. One factor that makes it extremely difficult to examine the constitutionality of a drug like midazolam is the fact that there is relatively little research on the effects of the drug where high dosages, such as the ones given to death row inmates, are used. Many studies involving midazolam look at its effects in low dosages. Therefore, when a medical expert testifies that midazolam is high enough to render an inmate insensate, or that it will not render an inmate insensate due to the ceiling effect, which I will touch on shortly, they are simply making a professional and educated guess. They are extrapolating the data from low-dosage midazolam studies and applying them to high-dosage scenarios to the best of their ability and knowledge. It would be unethical and dangerous to conduct a study where you, say, injected subjects with increasingly higher dosages of the drug and recorded their experiences. Kagan points out this frustrating uncertainty during Gross's oral arguments, where she asks the respondent's counsel, quote, "Do you think if we conclude that there is just a lot of uncertainty about this drug and it's really just impossible to tell its effects at higher doses because nobody does studies on this drug, it would be unethical to do studies on this drug, so we simply can't know the answer to these questions. If that's the state of the world, do you think it's a violation of the Eighth Amendment to use it?" Unquote. To this, Patrick Wyrick, the counsel for Gross, responds, quote, "If there is a risk of serious pain that rises to a substantial or objectively intolerable," at which point he's interrupted by Justice Kagan, who reframes the scenario to include that it is impossible to tell whether or not there is a risk of severe pain or objectively intolerable circumstances. There is some back and forth between Kagan and Wyrick before Wyrick argues that Kagan's scenario doesn't reflect reality. He argues that medical testimony in the trial court revealed that the dosage of midazolam administered to Oklahoma would render the inmate unconscious in 60 to 90 seconds. However, it does not end there. The medical expert used by Glossip at trial testified that while midazolam can render a person unconscious, it is only for a short period of time. Furthermore, midazolam is not used as a general anesthetic when long-term anesthesia is needed to keep a person unconscious and anesthetized for long periods of time. For example, during an invasive surgery that could take hours to complete, midazolam is often used to render the patient unconscious, at which point propofol is administered to keep them unconscious. It is Wyrick who brings this point up, but he's never given the chance to connect it back to his overarching point that midazolam's use in state executions passes constitutional muster, However, if I had to guess, I would say he brought it up because he's trying to make the point that death row inmates don't need to be unconscious for hours at a time. Most lethal injections occur in 6 to 9 minutes. For that purpose, I think Weyrich would argue midazolam is perfectly fine for sedating an inmate. A substantial portion of the oral arguments for both sides is dedicated to discussing something called a ceiling effect. In pharmacology, the ceiling effect is a phenomenon in which administering a greater dose of a drug provides no greater effect. So imagine, for example, I have a headache, so I take 2 Aleve pills. Those 2 pills are going to get rid of my headache just fine. If I take 10 Aleve pills, my headache isn't going to go away any faster, nor is it going to go away for longer. That is the basics of the ceiling effect. It's relevant to the midazolam discussion because the dosage where the ceiling effect kicks in for midazolam is unknown, but it's important nonetheless to determine whether Oklahoma's dosage of midazolam really renders the inmate unable to feel the pain of the other 2 drugs. Oklahoma's execution protocol calls for an injection of 100 milligrams of midazolam, while Florida's protocol calls for 500 milligrams of midazolam. These are both extremely large doses of midazolam, but imagine that the dosage where the ceiling effect kicked in was 400 milligrams. So at 400 milligrams, the inmate is unconscious and unable to feel pain. This means that Florida's execution protocol is perfectly constitutional, and in fact they are administering more than enough midazolam to the inmate. However, that would also mean that Oklahoma's 100 milligram dose is not enough. Inmates would still either feel pain or not be fully unconscious, or both. The problem becomes worse because there really is no way to know the dosage where the ceiling effect kicks in for midazolam. Because once you get into those high dose numbers like 100 or 500 milligrams, it's possible that whoever is receiving that dose would overdose and die from the midazolam alone. So you can't do a medical study on high doses of midazolam because that would require a doctor to administer increasingly high doses of midazolam until the patient overdosed, and that is plainly unethical. There have been a handful of studies that analyze midazolam's therapeutic uses in very small doses, but it is difficult to take these results of those studies in which midazolam was used in minuscule quantities and extrapolate them to doses that are several times larger. What this leads to is a back and forth between the petitioners and the respondents, where the petitioners are claiming that 100 milligrams of midazolam is not enough to fully anesthetize the inmate, and the respondents are saying that it is. It becomes clear that the conflicting testimony by medical experts from both parties during the initial trial is going to have to be sorted out somehow. According to the expert medical testimony for Gross, midazolam is an acceptable substitute for sodium thiopental that will not only render the inmate insensate, but even has the potential to kill them if either the vicuronium bromide or the potassium chloride malfunction. The expert medical testimony for Glossip, however, says pretty much the exact opposite. As Justice Breyer put it, quote, "What you have here is Glossip's experts saying that this drug will not keep you asleep. Once vicuronium bromide and potassium chloride are introduced, you will be jolted into consciousness. That is his testimony," unquote. So the court is going to have to devise some way to reconcile this he said, she said style of conflicting testimony. Ultimately, in a 5-4 decision, the Supreme Court of the United States is going to rule against Glossip. The majority, made up of Chief Justice John Roberts, Justices Antonin Scalia, Anthony Kennedy, Clarence Thomas, and Samuel Alito, hold that midazolam is a constitutional substitute for sodium thiopental that does not amount to cruel and unusual punishment. The dissent was formed by Justices Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elena Kagan. Justice Clarence Thomas wrote a concurring opinion, which was joined by Justice Antonin Scalia. Justice Antonin Scalia wrote a concurring opinion, which was joined by Justice Clarence Thomas. Justice Sotomayor wrote a dissenting opinion, which was joined by Justices Ginsburg, Breyer, and Kagan. And Justice Breyer wrote a dissenting opinion, which was joined by Justice Ginsburg. The majority opinion of the court, authored by Justice Samuel Alito, reads as follows. Prisoners sentenced to death in the state of Oklahoma filed an action in federal court contending that the method of execution now used by the state violates the Eighth Amendment because it creates an unacceptable risk of severe pain. They argue that midazolam, the first drug employed in the state's current 3-drug protocol, fails to render a person insensate to pain. After holding an evidentiary hearing, the district court denied 4 prisoners' application for a preliminary injunction, finding that they had failed to prove that midazolam is ineffective. The Court of Appeals for the 10th Circuit affirmed and accepted the district court's findings of fact regarding midazolam's efficacy. For 2 independent reasons, we also affirm. First, the prisoners failed to identify a known and available alternative method of execution that entails a lesser risk of pain, a requirement of all Eighth Amendment method of execution claims. Second, the district court did not commit clear error when it found that prisoners failed to establish that Oklahoma's use of a massive dose of midazolam in its execution protocol entails a substantial risk of severe pain. The death penalty was an accepted punishment at the time of the adoption of the Constitution and the Bill of Rights. In that era, death sentences were usually carried out by hanging. Hanging remained the standard method of execution through much of the 19th century, but that began to change in the century's later years. In the 1880s, the legislature of the state of New York appointed a commission to find, quote, the most humane and practical method known to modern science of carrying into effect the sentence of death in capital cases, unquote. The commission recommended electrocution, and in 1888, the legislature enacted a law providing for this method of execution. In subsequent years, other states followed New York's lead in the belief that electrocution is less painful and more humane than hanging. In 1921, the Nevada legislature adopted another new method of execution, lethal gas, after concluding that this was the most humane manner known to modern science. The Nevada Supreme Court rejected the argument that the use of lethal gas was unconstitutional, and other states followed Nevada's lead. Nevertheless, hanging and the firing squad were retained in some states, and electrocution remained the predominant method of execution until the 9-year hiatus in executions that ended with our judgment in Gregg v. Georgia. After Gregg reaffirmed that the death penalty does not violate the Constitution, some states once again sought a more humane way to carry out death sentences. They eventually adopted lethal injection, which today is by far the most prevalent method of execution in the United States. Oklahoma adopted lethal injection in 1977, and it eventually settled on a protocol that called for the use of 3 drugs: sodium thiopental, a fast-acting barbiturate sedative that induces a deep, coma-like unconsciousness when given in the amounts used for lethal injection; a paralytic agent, which inhibits all muscular skeletal movements and, by paralyzing the diaphragm, stops respiration; and potassium chloride, which interferes with the electrical signals that stimulate the contractions of the heart, inducing cardiac arrest. By 2008, at least 30 of the 36 states that used lethal injection employed that particular 3-drug protocol. While methods of executions have changed over the years, this court has never invalidated a state's chosen procedure for carrying out a sentence of death as the infliction of cruel and unusual punishment. In Wilkerson v. Utah, the court upheld a sentence of death by firing squad. In re Kemmler, the court rejected a challenge to the use of the electric chair, and the court did not retreat from that holding even when presented with a case in which a state's initial attempt to execute a prisoner by electrocution was unsuccessful. Most recently, in Bays v. Rees, 7 justices agreed that the 3-drug protocol just discussed does not violate the Eighth Amendment. Our decisions in this area have been animated in part by the recognition that because it is settled that capital punishment is constitutional, it necessarily follows that there must be a constitutional means of carrying it out. And because some risk of pain is inherent in any method of execution, we have held that the Constitution does not require the avoidance of all risk of pain. After all, while most humans wish to die a painless death, many do not receive that good fortune. Holding that the Eighth Amendment demands the elimination of essentially all risk of pain would effectively outlaw the death penalty altogether. Bays cleared any legal obstacle to use the most common 3-drug protocol that had enabled states to carry out the death penalty in a quick and painless fashion. But a practical obstacle soon emerged, as anti-death penalty advocates pressured pharmaceutical companies to refuse to supply the drugs used to carry out death sentences. The sole American manufacturer of sodium thiopental, the first drug used in the standard 3-drug protocol, was persuaded to cease production of the drug. After suspending the domestic production in 2009, the company planned to resume production in Italy. Activists then pressured both the company and the Italian government to stop the sale of sodium thiopental for use in lethal injections in this country. That effort proved successful, and in January 2011, the company announced that it would exit the sodium thiopental market entirely. After other efforts to procure sodium thiopental proved unsuccessful, states sought an alternative, and they eventually replaced sodium thiopental with pentobarbital, another barbiturate. In September 2010, Oklahoma became the first state to execute an inmate using pentobarbital. That execution occurred without incident, and states gradually shifted to pentobarbital as their supplies of sodium thiopental ran out. It is reported that pentobarbital was used in all of the 43 executions carried out in 2012. Petitioners concede that pentobarbital, like sodium thiopental, can reliably induce and maintain a coma-like state that renders a person insensate to pain, caused by administration of the second and third drugs in the protocol, and courts across the country have held that the use of pentobarbital in executions does not violate the Eighth Amendment. Before long, however, pentobarbital also became unavailable. Anti-death penalty advocates lobbied the Danish manufacturer of the drug to stop selling it for use in executions. That manufacturer opposed the death penalty and took steps to block the shipment of pentobarbital for use in executions in the United States. Oklahoma eventually became unable to acquire the drug through any means. The district court below found that both sodium thiopental and pentobarbital are now unavailable in Oklahoma. Unable to acquire either sodium thiopental or pentobarbital, some states have turned to midazolam, a sedative in the benzodiazepine family of drugs. In October 2013, Florida became the first state to substitute midazolam for pentobarbital as part of a 3-drug lethal injection protocol. To date, Florida has conducted 11 executions using that protocol, which calls for midazolam followed by a paralytic agent and potassium chloride. In 2014, Oklahoma also substituted midazolam for pentobarbital as part of its 3-drug protocol. Oklahoma has already used this 3-drug protocol twice to execute Clayton Lockett in April 2014 and Charles Warner in January 2015. Warner was one of the 4 inmates who moved for a preliminary injunction in this case. The Lockett execution caused Oklahoma to implement new safety precautions as part of its lethal injection protocol. When Oklahoma executed Lockett, its protocol called for the administration of 100 milligrams of midazolam as compared to the 500 milligrams that are currently required. On the morning of his execution, Lockett cut himself twice at the bend of the elbow. That evening, the execution team spent nearly an hour making at least 12 attempts to establish intravenous access to Lockett's cardiovascular system, including at his arms and elsewhere on his body. The team eventually believed that it had established intravenous access through Lockett's right femoral vein, and it covered the injection access point with a sheet, in part to preserve Lockett's dignity during the execution. After the team administered the midazolam and a physician determined that Lockett was unconscious, the team next administered the paralytic agent vicuronium bromide and most of the potassium chloride. Lockett began to move and speak, at which point the physician lifted the sheet and determined that the IV had infiltrated, which means that the IV fluid, rather than entering Lockett's bloodstream, had leaked into the tissue surrounding the IV access point. The execution team stopped administering the remaining potassium chloride and terminated the execution about 33 minutes after the midazolam was first injected. About 10 minutes later, Lockett was pronounced dead. An investigation into the Lockett execution concluded that the viability of the IV access point was the single greatest factor that contributed to the difficulty in administering the execution drugs. The investigation, which took 5 months to complete, recommended several changes to Oklahoma's execution protocol, and Oklahoma adopted a new protocol with an effective date of September 30th, 2014. That protocol allows the Oklahoma Department of Corrections to choose among 4 different drug combinations. The option that Oklahoma plans to use to execute petitioners calls for the administration of 500 milligrams of midazolam, followed by a paralytic agent and potassium chloride. The paralytic agent may be pancuronium bromide, vicuronium bromide, rocuronium bromide, 3 drugs that all agree are functionally equivalent for purposes of this case. The protocol also includes procedural safeguards to help ensure that an inmate remains insensate to any pain caused by the administration of the paralytic agent and potassium chloride. Those safeguards include the insertion of both a primary and backup IV catheter, procedures to confirm the viability of the IV site, the option to postpone an execution if viable IV sites cannot be established within an hour, a mandatory pause between administration of the first and second drugs, numerous procedures for monitoring the offender's consciousness, including the use of an electrocardiograph and direct observation, and detailed provisions with respect to the training and preparation of the execution team. In January of this year, Oklahoma executed Warner using these revised procedures and the combination of midazolam, a paralytic agent, and potassium chloride. In June 2014, after Oklahoma switched from pentobarbital to midazolam and executed Lockett, 21 Oklahoma death row inmates filed an action challenging the state's new lethal injection protocol. The complaint alleged that Oklahoma's use of midazolam violates the Eighth Amendment's prohibition of cruel and unusual punishment. In November 2014, 4 of those plaintiffs, Richard Glossip, Benjamin Cole, John Grant, and Warner, filed a motion for preliminary injunction. All 4 men had been convicted of murder and sentenced to death by Oklahoma juries. Glossip hired Justin Sneed to kill his employer Barry Vantrease. Sneed entered a room where Vantrease was sleeping and beat him to death with a baseball bat. Cole murdered his 9-month-old daughter after she would not stop crying. Cole bent her body backwards until he snapped her spine in half. After the child died, Cole played video games. Grant, while serving terms of imprisonment totaling 130 years, killed Gay Carter, a prison food service supervisor, by pulling her into a mop closet and stabbing her numerous times with a shank. Warner anally raped and murdered an 11-month-old girl. The child's injuries included 2 skull fractures, internal brain injuries, 2 fractures to her jaw, a lacerated liver, and a bruised spleen and lungs. The Oklahoma Court of Criminal Appeals affirmed the murder conviction and death sentence of each offender. Each of the men then unsuccessfully sought both state post-conviction and federal habeas corpus relief. Having exhausted the avenues for challenging their convictions and sentences, they moved for a preliminary injunction against Oklahoma's lethal injection protocol. In December 2014, after discovery, the district court held a 3-day evidentiary hearing on the preliminary injunction motion. The district court heard testimony from 17 witnesses and reviewed numerous exhibits. Dr. David Lubarsky, an anesthesiologist, and Dr. Larry Sasik, a doctor of pharmacy, provided expert testimony about midazolam for petitioners, and Dr. Roswell Evans, doctor of pharmacy, provided expert testimony for respondents. After reviewing the evidence, the district court issued an oral ruling denying the motion for a preliminary injunction. The district court first rejected petitioners to the testimony of Dr. Evans. It concluded that Dr. Evans, the dean of Auburn University's School of Pharmacy, was well qualified to testify about midazolam's properties and that he offered reliable testimony. The district court then held that petitioners failed to establish a likelihood of success on the merits of their claim that the use of midazolam violates the Eighth Amendment. The court provided 2 independent reasons for this conclusion. First, the court held that petitioners failed to identify a known and available method of execution that presented a substantially less severe risk of pain than the method that the state proposed to use. Second, the court found that petitioners failed to prove that Oklahoma's protocol presents a risk that is sure or very likely to cause serious illness and needless suffering, amounting to an objectively intolerable risk of harm. The court emphasized that the Oklahoma protocol featured numerous safeguards, including the establishment of 2 IV access sites, confirmation of the viability of those sites, and monitoring of the offender's level of consciousness throughout the procedure. The district court supported its decision with findings of fact about midazolam. It found that a 500 milligram dose of midazolam would make it a virtual certainty that any individual will be at a sufficient level of unconsciousness to resist the noxious stimuli which could occur from the application of the second and third drugs. Indeed, it found that a 500 milligram dose alone would likely cause death by respiratory arrest within 30 minutes or an hour. The Court of Appeals for the 10th Circuit affirmed. The Court of Appeals explained that our decision in Bays requires a plaintiff challenging a lethal injection protocol to demonstrate that the risk of severe pain presented by an execution protocol is substantial when compared to the known and available alternatives, and it agreed with the district court that petitioners had not identified any such alternative. The Court of Appeals added, however, that this holding was not outcome determinative in this case because petitioners additionally failed to establish that the use of midazolam creates a demonstrated risk of severe pain. The Court of Appeals found that the district court did not abuse its discretion by relying on Dr. Evans' testimony, and it concluded that the district court's factual findings about midazolam were not clearly erroneous. It also held that the alleged errors in Dr. Evans' testimony did not render his testimony unreliable or the district court's findings clearly erroneous. Oklahoma executed Warner on January 15, 2015, but we subsequently voted to grant review and then stayed the executions of Glossip, Cole, and Grant pending the resolution of this case. A plaintiff seeking a preliminary injunction must establish that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of preliminary relief, and the balance of equities tips in his favor, and that an injunction is in the public interest. The parties agree that this case turns on whether petitioners are able to establish a likelihood of success on the merits. The Eighth Amendment, made applicable to the states through the 14th Amendment, prohibits the infliction of cruel and unusual punishments. The controlling opinion in Bays outlined what a prisoner must establish to succeed on an Eighth Amendment method of execution claim. Bays involved a challenge by Kentucky death row inmates to that state's three-drug lethal injection protocol of sodium thiopental, pancuronium bromide, and potassium chloride. The inmates conceded that the protocol, if properly administered, would result in a humane and constitutional execution because sodium thiopental would render an inmate oblivious to any pain caused by the second and third drugs. But they argued that there was an unacceptable risk that sodium thiopental would not be properly administered. The inmates also maintained that a significant risk of harm could be eliminated if Kentucky adopted a one-drug protocol and additional monitoring by trained personnel. The controlling opinion in Bays first concluded that prisoners cannot successfully challenge a method of execution unless they establish that the method presents a risk that is sure or very likely to cause serious illness and needless suffering, and give rise to sufficiently imminent dangers. To prevail on such a claim, there must be a substantial risk of serious harm, an objectively intolerable risk of harm that prevents prison officials from pleading that they were subjectively blameless for purposes of the Eighth Amendment. The controlling opinion also stated that prisoners cannot successfully challenge a state's method of execution merely by showing a slightly or marginally safer alternative. Instead, prisoners must identify an alternative that is feasible, readily implemented, and in fact significantly reduces a substantial risk of severe pain. The controlling opinion summarized the requirements of an Eighth Amendment method of execution as follows. A stay of execution may not be granted on grounds such as those asserted here unless the condemned prisoner establishes that the state's lethal injection protocol creates a demonstrated risk of severe pain, and he must show that the risk is substantial when compared to the known and available alternatives. The preliminary injunction posture of the present case thus requires petitioners to establish a likelihood that they can establish both that Oklahoma's lethal injection protocol creates a demonstrated risk of severe pain and that the risk is substantial when compared to known and available alternatives. The challenge in Bays failed both because the Kentucky inmates did not show that the risks they identified were substantial and imminent, and because they did not establish the existence of a known and available alternative method of execution that would entail a significantly less severe risk. Petitioners' arguments here fail for similar reasons. First, petitioners have not proved that any risk posed by midazolam is substantial when compared to known and available alternative methods of execution. Second, they have failed to establish that the district court committed clear error when it found that the use of midazolam will not result in severe pain and suffering. We address each reason in turn. Our first ground for affirmance is based on petitioners' failure to satisfy their burden of establishing that any risk of harm was substantial when compared to a known and available alternative method of execution. In their amended complaint, petitioners proffered that the state could use sodium thiopental as part of a single drug protocol. They have since suggested that it might also be constitutional for Oklahoma to use pentobarbital, but the district court found that both sodium thiopental and pentobarbital are now unavailable to Oklahoma's Department of Corrections. The Court of Appeals affirmed that finding, and it is not clearly erroneous. On the contrary, the record shows that Oklahoma has been unable to procure those drugs despite a good faith effort to do so. Petitioners do not seriously contest this factual finding, and they have not identified any available drug or drugs that could be used in place of those that Oklahoma is now unable to obtain. Nor have they shown a risk of pain so great that other acceptable available methods must be used. Instead, they argue that they need not identify a known and available alternative method of execution that presents less risk. But this argument is inconsistent with the controlling opinion in Bays, which imposed a requirement that the court now follows. Petitioners contend that the requirement to identify an alternative method of execution contravenes our pre-Bays decision in Hill v. McDonough, but they misread that decision. The portion of the opinion in Hill on which they rely concerned a question of civil procedure, not a substantive Eighth Amendment question. In Hill, the issue was whether a challenge to a method of execution must be brought by means of an application for a writ of habeas corpus or a civil action under Section 1983. We held that a method of execution claim must be brought under Section 1983 because such a claim does not attack the validity of the prisoner's conviction or death sentence. The United States, as amicus curiae, argued that we should adopt a special pleading requirement to stop inmates from using Section 1983 actions to attack not just a particular means of execution, but the death penalty itself. To achieve this end, the United States proposed that an inmate asserting a method of execution claim should be required to plead an acceptable alternative method of execution. We rejected that argument because specific pleading requirements are mandated by the Federal Rules of Civil Procedures and not as a general rule through case-by-case determinations of the federal courts. Hill thus held that Section 1983 alone does not impose a heightened pleading requirement. Bayes, on the other hand, addressed the substantive elements of an Eighth Amendment method of execution claim, and it made clear that the Eighth Amendment requires a prisoner to plead and prove a known and available alternative. Because petitioners failed to do this, the district court properly held that they did not establish a likelihood of success on their Eighth Amendment claim. Readers can judge for themselves how much distance there is between the principal dissent's argument against requiring prisoners to identify an alternative and the view now announced by Justices Breyer and Ginsburg that the death penalty is categorically unconstitutional. The principal dissent goes out of its way to suggest that a state would violate the Eighth Amendment if it used one of the methods of executions employed before the advent of lethal injection, and the principal dissent makes this suggestion even though the court held in Wilkerson that this method, the firing squad, is constitutional, and even though, in the words of the principal dissent, there is some reason to think that it is relatively quick and painless. Tellingly silent about the method of execution most commonly used before states switched to lethal injection, the electric chair and gas chamber, the principal dissent implies that it would be unconstitutional to use a method that could be seen as a devolution to a more primitive era. If states cannot return to any of the more primitive methods used in the past, and if no drug that meets with the principal dissent's approval is available for use in carrying out a death sentence, the logical conclusion is clear. We declined to effectively overrule these decisions. We also affirm for a second reason. The district court did not commit clear error when it found that midazolam is highly likely to render a person unable to feel pain during an execution. We emphasize 4 points at the outset of our analysis. First, the district court's factual findings under the deferential clear error standard. This standard does not entitle us to overturn a finding simply because we are convinced that we would have decided the case differently. Second, petitioners bear the burden of persuasion on the issue. Although petitioner expends great effort attacking peripheral aspects of Dr. Evans's testimony, they make little attempt to prove what is critical, i.e., that the evidence they presented to the district court establishes that the use of midazolam is sure or very likely to result in needless suffering. Third, numerous courts have concluded that the use of midazolam as the first drug in a 3-drug protocol is likely to render an inmate insensate to pain that might result from administration of the paralytic agent and potassium chloride. Where an intermediate court reviews and affirms a trial court's factual findings, this court will not lightly overturn the concurrent findings of the 2 lower courts. Our review is even more deferential here, as here, multiple trial courts have reached the same finding, and multiple appellate courts have affirmed those findings. Fourth, challenges to lethal injection protocols test the boundaries of the authority and competency of federal courts. Although we must invalidate a lethal injection protocol if it violates the Eighth Amendment, federal courts should not embroil themselves in ongoing scientific controversies beyond their expertise. Accordingly, an inmate challenging a protocol bears the burden to show, based on evidence presented to the court, that there is substantial risk of severe pain. Petitioners attack the district court's findings of fact on 2 main grounds. First, they argue that even if midazolam is powerful enough to induce unconsciousness, it is too weak to maintain unconsciousness and insensitivity to pain once the second and third drugs are administered. Second, while conceding that the 500 mg dose of midazolam is much higher than the normal therapeutic dose, they contend that this fact is irrelevant because midazolam has a ceiling effect. That is, at a certain point, an increase in the dose administered will not have any greater effect on the inmate. Neither argument succeeds. The district court found that midazolam is capable of placing a person at a sufficient level of unconsciousness to resist the noxious stimuli, which could occur from the application of the second and third drugs. This conclusion was not clearly erroneous. Respondent's experts, Dr. Evans, testified that the proper administration of a 500 milligram dose of midazolam would make it a virtual certainty that an individual would be at a sufficient level of unconsciousness to resist the noxious stimuli which could occur from the application of the second and third drugs used in the Oklahoma Protocol. And petitioner's experts acknowledged that they had no contrary scientific proof. In an effort to explain this dearth of evidence, Dr. Sasek testified that it is not my responsibility or the Food and Drug Administration's responsibility to prove that the drug doesn't work or is not safe. Instead, he stated, it's the responsibility of the proponent to show that the drug is safe and effective. Dr. Sasek confused the standard imposed on a drug manufacturer seeking approval of a therapeutic drug with the standard that must be borne by a party challenging a state lethal injection protocol. When a method of execution is authorized under state law, a party contending that this method violates the Eighth Amendment bears the burden of showing that the method creates an unacceptable risk of pain. Here, petitioners' own experts effectively conceded that they lacked evidence to prove their case beyond dispute. Petitioners attempt to avoid this deficiency by criticizing respondent's expert. They argue that the district court should not have credited Dr. Evans' testimony because he admitted that his findings were based on extrapolations from studies done about much lower therapeutic doses of midazolam. But because a 500 milligram dose is never administered for a therapeutic purpose, extrapolation was reasonable, and the conclusions of petitioners' experts were also based on extrapolations and assumptions. For example, Dr. Lubarsky relied on extrapolation of the ceiling effect data. Based on the evidence that the parties presented to the district court, we must affirm. Testimony from both sides supports the district court's conclusion that midazolam can render a person insensate to pain. Dr. Evans testified that although midazolam is not an analgesic, it can nonetheless render the person unconscious and insensate during the remainder of the procedure. In his discussion about the ceiling effect, Dr. Sasek agreed that as the dose of midazolam increases, it is expected to produce sedation, amnesia, and finally lack of response to stimuli such as pain. Petitioners argue that midazolam is not powerful enough to keep a person insensate to pain after the administration of the second and third drugs, but Dr. Evans presented credible testimony to the contrary. Indeed, low doses of midazolam are sufficient to induce unconsciousness and are even sometimes used as the sole relevant drug in certain medical procedures. Dr. Sasek conceded, for example, that midazolam might be used for medical procedures like colonoscopies and gastroscopies. Petitioners emphasized that midazolam is not recommended or approved for the use as the sole anesthetic during painful surgery, but there are two reasons why this is not dispositive. First, as the district court found, the 500 milligram dose at issue here is many times higher than a normal therapeutic dose of midazolam. The effect of a small dose of midazolam has minimal probative value about the effect of a 500 milligram dose. Second, the fact that a low dose of midazolam is not the best drug for maintaining unconsciousness during surgery says little about whether a 500 milligram dose of midazolam is constitutionally adequate for the purposes of conducting an execution. We recognized this point in Bayes, where we concluded that although the medical standard of care might require the use of a blood pressure cuff and an electrocardiogram during surgeries, this does not mean those procedures are required for an execution to pass Eighth Amendment scrutiny. Oklahoma has also adopted important safeguards to ensure that midazolam is properly administered. The district court emphasized three requirements in particular. The execution team must secure both a primary and backup IV access site, it must confirm the viability of the IV sites, and it must continuously monitor the offender's level of consciousness. The district court did not commit clear error in concluding that these safeguards help to minimize any risk that might occur in the event that midazolam does not operate as intended. Indeed, we concluded in Bayes that many of the safeguards that Oklahoma employs, including the establishment of a primary and backup IV and the presence of personnel to monitor an inmate, help in significantly reducing the risk that an execution protocol will violate the Eighth Amendment. And many other safeguards that Oklahoma has adopted mirror those that the dissent in Bayes complained were absent from Kentucky's protocol in that case. For example, the dissent argues that because a consciousness check before injection of the second drug can reduce a risk of dreadful pain, Kentucky's failure to include that step in its procedure was unconstitutional. The dissent also complained that Kentucky did not monitor the effectiveness of the first drug or pause between injection of the first and second drugs. Oklahoma has accommodated each of those concerns. Petitioners assert that midazolam's ceiling effect undermines the district court's findings about the effectiveness of the huge dose administered in the Oklahoma protocol. Petitioners argue that midazolam has a ceiling above which any increase in dosage produces no effect. As a result, they maintain it is wrong to assume that a 500 milligram dose has a much greater effect than a therapeutic dose of about 5 milligrams. But the mere fact that midazolam has such a ceiling cannot be dispositive. Dr. Sasek testified that all drugs essentially have a ceiling effect. The relevant question is whether midazolam's ceiling effect occurs below the level of a 500 milligram dose and at a point which the drug does not have the effect of rendering a person insensate to pain caused by the second and third drugs. Petitioners provided little probative evidence on this point, and the speculative evidence that they did present to the district court does not come close to establishing that his factual findings were clearly erroneous. Dr. Sasek stated in his expert report that the literature indicates that midazolam has a ceiling effect, but he conceded that he was unable to determine the midazolam dose for a ceiling effect on unconsciousness because there is no literature in which such testing has been done. Dr. Lubarsky's report was similar, and the testimony of petitioners' experts at the hearing was no more compelling. Dr. Sasek frankly admitted that he did a search to try and determine at what dose of midazolam you would get a ceiling effect, but concluded I could not find one. The closest petitioners came was Dr. Lubarsky's suggestion that the ceiling effect occurs probably after about 40 to 50 milligrams, but he added that he had not actually done the relevant calculations, and he admitted, I can't tell you right now at what dose the ceiling effect occurs. We cannot conclude that the district court committed clear error in declining to find, based on such speculative evidence, that the ceiling effect negates midazolam's ability to render an inmate insensate to pain caused by the second and third drugs in the protocol. The principal dissent discusses the ceiling effect at length, but it studiously avoids suggesting that petitioners presented probative evidence about the dose at which the ceiling effect occurs or about whether the effect occurs before a person becomes insensate to pain. The principal dissent avoids these critical issues by suggesting that such evidence is irrelevant if there is no dose at which the drug can render a person insensate to pain. But the district court heard evidence that the drug can render a person insensate to pain, and not just from Dr. Evans. Dr. Sasek, one of petitioners' own experts, testified that higher doses of midazolam are expected to produce lack of response to stimuli such as pain. In their brief, petitioners attempt to deflect attention from their failure of proof regarding midazolam's ceiling effect by criticizing Dr. Evans' testimony. But it was petitioners' burden to establish that midazolam's ceiling occurred at a dosage below the 500 milligram dose employed by the Oklahoma protocol, and at a point at which the drug failed to render the recipient insensate to pain. They did not meet that burden, and their criticisms do not undermine Dr. Evans' central point, which the district court credited, that a properly administered 500 milligram dose of midazolam will render the recipient unable to feel pain. One of petitioners' criticisms of Dr. Evans' testimony is little more than a quibble about the wording chosen by Dr. Evans at one point in his oral testimony. Petitioner's expert Dr. Lubarsky stated in his report that midazolam increases effective binding of GABA to its receptor to induce unconsciousness. Dr. Evans' report provided a similar explanation of the way in which midazolam works, and Dr. Lubarsky did not dispute the accuracy of that explanation when he testified at the hearing. Petitioners contend, however, that Dr. Evans erred when he said at the hearing that midazolam attaches to GABA receptors inhibiting GABA. Petitioners contend that his statement was incorrect because, far from inhibiting GABA, midazolam facilitates its binding to the GABA receptors. In making this argument, petitioners are simply quarreling with words that Dr. Evans used during oral testimony in an effort to explain how midazolam works in terms understandable to a layman. Petitioners do not suggest that the discussion of midazolam in Dr. Evans' expert report was inaccurate, and as for Dr. Evans' passing use of the term inhibiting, Dr. Lubarsky's own expert report states that GABA's inhibition of brain activity is accentuated by midazolam. Dr. Evans' oral use of the word inhibiting, particularly in light of his written testimony, does not invalidate the district court's decision to rely on his testimony. Petitioners also point to an apparent conflict between Dr. Evans' testimony and a declaration by Dr. Lubarsky submitted after the district court ruled regarding the biological process that produces midazolam's ceiling effect. But even if Dr. Lubarsky's declaration is correct, it is largely beside the point. What matters for present purposes is the dosage at which the ceiling effect kicks in, not the biological process that produces the effect, and Dr. Lubarsky's declaration does not render the district court's findings clearly erroneous with respect to that critical issue. Petitioner's remaining arguments about midazolam all lack merit. First, we are not persuaded by petitioner's claim that Dr. Evans's testimony should have been rejected because of some of the sources listed in his report. Petitioners criticize two of the selected references that Dr. Evans cites in his report, the website drugs.com and a material safety data sheet about midazolam. Petitioner's argument is more of a Dober challenge to Dr. Evans's testimony than an argument that the district court's findings were clearly erroneous. The district court concluded that Dr. Evans was well qualified to give the expert testimony that he gave, and that his testimony was the product of reliable principles and methods reliably applied to the facts of this case. To the extent that the reliability of Dr. Evans's testimony is even before us, the district court's conclusion that his testimony was based on reliable sources is reviewed under the deferential abuse of discretion standard. Dr. Evans relied on multiple sources and his own expertise, and his testimony may not be disqualified simply because one source, drugs.com, warns that it is not intended for medical advice, and another, the material safety data sheet, states that its information is provided without any warranty, express or implied, regarding its correctness. Medical journals that both parties rely upon typically contain similar disclaimers. Dr. Lubarsky, petitioner's own expert, relied on an MSDS to argue that midazolam has a ceiling effect, and petitioners do not identify any incorrect statements from drugs.com on which Dr. Evans relied. In fact, although Dr. Sasik submitted a declaration to the Court of Appeals criticizing Dr. Evans's reference to drugs.com, that declaration does not identify a single fact from the site's discussion of midazolam that was materially inaccurate. Second, petitioners argue that Dr. Evans's expert report contained a mathematical error, but we find this argument insignificant. Dr. Evans stated in his expert report that the lowest dose of midazolam resulting in human deaths, according to the MSDS, is 0.071 milligrams per kilogram delivered intravenously. Dr. Lubarsky agreed with this statement. Specifically, he testified that fatalities have occurred in doses ranging from 0.04 to 0.07 milligrams per kilogram, and he stated that Dr. Evans's testimony to that effect was a true statement, though he added those fatalities occurred among the elderly. We do not understand petitioners to dispute the testimony of Dr. Evans and their own expert that 0.071 milligrams per kilogram is a potentially fatal dose of midazolam. Instead, they make much of the fact that the MSDS attached to Dr. Evans's report apparently contained a typographical error and reported the lowest toxic dose as 71 milligrams per kilogram. That Dr. Evans did not repeat that incorrect figure but instead reported the correct dose supports rather than undermines his testimony. In any event, the alleged error in the MSDS is irrelevant because the district court expressly stated that it did not rely on the figure in the MSDS. Third, petitioners argue that there is no consensus among the states regarding midazolam's efficacy because only 4 states, Oklahoma, Arizona, Florida, and Ohio, have used midazolam as part of an execution. Petitioners rely on the plurality statement in Bayes that it is difficult to regard a practice as objectively intolerable when it is in fact widely tolerated, and the plurality's emphasis on the fact that 36 states had adopted lethal injection and 30 states used the particular 3-drug protocol at issue in that case. But while the near-universal use of the particular protocol at issue in Bayes supported our conclusion that this protocol did not violate the Eighth Amendment, we did not say that the converse was true, i.e., that other protocols or other methods of execution are of doubtful constitutionality. That argument, if accepted, would hamper the adoption of new and potentially more humane methods of execution and would prevent the states from adapting to changes in the availability of suitable drugs. Fourth, petitioners argue that difficulties with Oklahoma's execution of Lockett and Arizona's July 2014 execution of Joseph Wood establish that midazolam is sure or very likely to cause serious pain. We are not persuaded. Aside from the Lockett execution, 12 other executions have been conducted using the 3-drug protocol at issue here, and those appear to have been conducted without any significant problems. Moreover, Lockett was administered only 100 milligrams of midazolam, An Oklahoma investigation into that execution concluded that the difficulties were due primarily to the execution team's inability to obtain an IV access site, and the Wood execution did not involve the protocol at issue here. Wood did not receive a single dose of 500 milligrams of midazolam. Instead, he received 15 50-milligram doses over the span of 2 hours, and Arizona used a different two-drug protocol that paired midazolam with hydromorphone, a drug that is not at issue in this case. When all of the circumstances are considered, the Lockett and Wood executions have little probative value for present purposes. Finally, we find it appropriate to respond to the principal dissent's groundless suggestion that our decision is tantamount to allowing prisoners to be drawn and quartered, slowly tortured to death, or actually burned at the stake. That is simply not true, and the principal dissent's resort to the outlandish rhetoric reveals the weakness of its legal arguments. For these reasons, the judgment of the Court of Appeals for the Tenth Circuit is affirmed. It is so ordered. So, speaking for the court, Justice Alito holds that the use of midazolam as the first drug in Oklahoma's 3-drug execution protocol does not constitute cruel and unusual punishment. He gets here by concluding that 1. Petitioners failed to meet the standards set in Bays v. Rees, and 2. Petitioners failed to prove that any obvious or damning errors were made during the factual findings in trial court. Regarding the first point, Bays v. Rees is a separate death penalty case from 2008 that I'm not going to get into right now, other than to say that the precedent set in Bays is that anybody challenging a method of execution must prove that the method of execution they're challenging has the risk of inflicting upon them severe pain relative to other known and available methods of execution. Here, the court holds that Glossip failed to do that. The court has held in prior cases and emphasized in this one that the Eighth Amendment does not ensure a painless execution. Instead, it only prohibits executions that impose severe, unnecessary, or undignifying amounts of pain. As I said earlier, the court was going to need to come up with a way to reconcile the disputes between petitioners and respondents where both sides were saying opposite things regarding crucial facts of the case, such as the ceiling effect and the drug's ability to stop an inmate from feeling pain. That reconciliation happens in the opinion, with Alito articulating essentially that the trial court has to give deference to the medical testimony for the state, and it's the inmate's job to prove them wrong. In this instance, Glossip failed to disprove the state's claim that the dosage of midazolam given to inmates was high enough to incapacitate and prevent the inmate from feeling pain. This failure to disprove the claims of the state meant that the trial court, in giving deference to the state's testimony, could only conclude that midazolam would render the inmate unconscious and unfeeling long enough for the subsequent 2 drugs to have their effects. This, in turn, also meant that Glossip could not prove that any clear factual errors were made at trial court, thus leading to the decision in the Supreme Court to affirm the decision of the trial court instead of overturning it as Glossip had hoped. Clarence Thomas wrote a concurring opinion joined by Justice Scalia in which he said, "I agree with the court that petitioner's Eighth Amendment claim fails. That claim has no foundation in the Eighth Amendment, which prohibits only those methods of execution that are deliberately designed to inflict pain. Because petitioners make no allegation that Oklahoma adopted its lethal injection protocol to add elements of terror, pain, or disgrace to the death penalty, they have no valid claim. That should have been the end of this case. But our precedents have predictably transformed the federal courts into boards of inquiry charged with determining the best practices for executions, necessitating the painstaking factual inquiry the court undertakes today. Although I continue to believe that the broader interpretation of the court's Eighth Amendment advanced in the plurality opinion in Bays is erroneous, I join the court's opinion in full because it correctly explains why petitioner's claim fails even under that controlling opinion. I write separately to respond to Justice Breyer's dissent questioning the constitutionality of the death penalty generally. No more need be said about the constitutional arguments on which Justice Breyer relies, as my colleagues and I have elsewhere refuted them. But Justice Breyer's assertion that the death penalty in this country has fallen short of the aspiration that capital punishment be reserved for the worst of the worst, a notion itself based on an implicit proportionality principle that has long been discredited, merits further comment. His conclusion is based on an analysis that it itself provides a powerful case against enforcing an imaginary constitutional rule against arbitrariness. The thrust of Justice Breyer's argument is that empirical studies performed by death penalty abolitionists reveal that the assignment of death sentences does not necessarily correspond to the egregiousness of the crimes, but instead appears to be correlated to arbitrary factors, such as the locality in which the crime was committed. Relying on these studies to determine the constitutionality of the death penalty fails to respect the values implicit in the Constitution's allocation of decision-making in this context. The Donahue study, which Justice Breyer relies most heavily, measured the egregiousness or death-worthiness of murders by asking lawyers to identify the legal grounds for aggravation in each case, and by asking law students to evaluate written summaries of the murders and assign egregiousness scores based on a rubric designed to capture and standardize their moral judgments. This exercise in some way approximates the function performed by jurors, but there is at least one critical difference. The law students make their moral judgments based on written summaries. They do not sit through hours, days, or weeks of evidence detailing the crime. They do not have an opportunity to assess the credibility of the witnesses, to see the remorse of the defendant, to feel the impact of the crime on the victim's family. They do not bear the burden of deciding the fate of another human being, and they are not drawn from the community whose sense of security and justice may have been torn asunder by an act of callous disregard for human life. They are like appellate judges and justices, reviewing only a paper record of each side's case for life or death. There is a reason the choice between life and death, between legal limits, is left to jurors and judges who sit through the trial, and not to legal elites or law students. That reason is memorialized not once, but twice in our Constitution. Article 3 guarantees that the trial of all crimes, except in cases of impeachment, shall be by jury, and that such trial shall be held in the state where the said crimes shall have been committed. And the Sixth Amendment promises that in all criminal prosecutions, the accused shall enjoy the right to a trial by an impartial jury of the state and district wherein the crime shall have been committed. Those provisions ensure that capital defendants are given the option to be sentenced by a jury of their peers who collectively are better situated to make the moral judgment between life and death than are products of the contemporary American law schools. It should come as no surprise, then, that the primary explanation a regression analysis revealed for the gap between the egregiousness scores and the actual sentences was not the race or sex of the offender or victim, but the locality in which the crime was committed. What is more surprising is that Justice Breyer considers this factor to be evidence of arbitrariness. The constitutional provisions just quoted, which placed such decisions in the hands of jurors and trial courts located where the crime shall have been committed, seem deliberately designed to introduce that factor. In any event, the results of these studies are inherently unreliable because they purport to control for egregiousness by quantifying moral depravity in a process that is itself arbitrary, not to mention dehumanizing. One such study's explanation of how the author assigned depravity points to identify the worst of the worst murderers proves the point as well. Each aggravating factor received a point value based on the blameworthiness of the action associated with it. Killing a prison guard, for instance, earned a defendant 3 depravity points because it improved the case for complete incapacitation, while killing a police officer merited only 2 because, considered dispassionately, such acts do not seem to be a sine qua non of the worst criminals. Do not worry, the author reassures us. Many killers of police officers accrue depravity points in other ways that clearly put them among the worst criminals. Killing a child under the age of 12 was worth 2 depravity points because such an act seems particularly heartless, but killing someone over the age of 70 earned the murderer only 1. For although elderly victims tug at our hearts, they do so less than children because the promise of a long life is less. Killing to make a political statement was worth 3 depravity points. Killing out of racial hatred, only 2. It goes on, but this small sample of the moral judgments on which this study rested shows just how unsuitable this evidence is to serve as a basis for a judicial decision declaring unconstitutional a punishment enacted in more than 30 states, and by the federal government. We owe victims more than this sort of pseudoscientific assessment of their lives. It is bad enough to tell a mother that her child's murder is not worthy of society's ultimate expression of moral condemnation. But to do so based on cardboard stereotypes or cold mathematical calculations is beyond my comprehension. In my decades on the court, I have not seen a capital crime that could not have been considered sufficiently blameworthy to merit a death sentence, even when genuine constitutional errors justified a vacatur of that sentence. A small sample of the applications for a stay of execution that have come before the court this term alone proves my point. Mark Christensen was due to be executed in October 2014 for his role in the murder of Susan Brooke and her young children Adrian and Kyle. After raping Miss Brooke at gunpoint, he and his accomplice drove the family to a remote pond where Christensen cut Miss Brooke's throat with a bone knife. Although bleeding profusely, she stayed alive long enough to tell her children she loved them and to watch as Christensen murdered them, her son by cutting his throat and drowning him, her daughter by pressing her down on her throat until she suffocated. Christensen and his accomplice then threw Miss Brooke, alive but barely breathing, into the pond to drown on top of her dead children. This court granted him a stay of execution. When he died, Devante had over 250 distinct injuries, including cigarette burns and ligature marks, on his 36-pound frame. Infections from untreated wounds contributed to his other cause of death, pneumonia. And Johnny Shane Cormandi, who met his end on January 15, 2015, did so after he and his two accomplices invaded the home of a married couple, took turns raping his wife and forcing her to perform oral sex at gunpoint, at one point doing both simultaneously, and then put a bullet in her husband's head during the final rape. Some of our most egregious cases have been those in which we have granted relief based on an unfounded Eighth Amendment claim. For example, we have granted relief in a number of egregious cases based on this court's decision in Atkins v. Virginia, exempting certain mentally retarded offenders from the death penalty. Last term, the court granted relief to a man who kidnapped, beat, raped, and murdered a 21-year-old pregnant newlywed, Carol Hurst, also murdering her unborn child, and then on the same day murdered a sheriff's deputy acting in the line of duty. And in Atkins itself, the court granted relief to a man who carjacked Eric Michael Nesbitt, forced him to withdraw money from a bank, drove him to a secluded area, and then shot him multiple times before leaving him to bleed to death. The court has also misinterpreted the Eighth Amendment to grant relief in egregious cases involving rape. In Kennedy v. Louisiana, the court granted relief to a man who had been sentenced to death for raping his 8-year-old stepdaughter. The rape was so violent that it separated her cervix from the back of her vagina, causing her rectum to protrude into the vaginal structure, and tore her entire perineum from the posterior fourchette to the anus. The evidence indicated that the petitioner spent at least an hour and a half attempting to destroy the evidence of his crime before seeking emergency assistance, even as his stepdaughter bled profusely from her injuries. And in Coker v. Georgia, the court granted relief to a petitioner who had escaped from prison, broken into the home of a young married couple and their newborn, forced the wife to bind her husband, gagged her husband with her underwear, raped her even after being told that she was recovering from a recent childbirth, and then kidnapped her after threatening her husband. In each case, the court crafted an Eighth Amendment right to be free from execution for the crime of rape, whether it be of an adult or a child. The court's recent decision finding that the Eighth Amendment prohibits the execution of those who committed their crimes even as juveniles is no different. Although the court had rejected the claim less than 2 decades earlier, it decided to revisit the issue for a petitioner who had slain his victim because he wanted to murder someone and believed he could get away with it because he was a few months shy of his 18th birthday. His randomly chosen victim was Shirley Crook, whom he and his friends kidnapped in the middle of the night, bound with duct tape and electrical wire, and threw off a bridge to drown in the river below. The state of Alabama's brief in that case warned the court that its decision would free from death row a number of killers who had been sentenced for crimes committed as juveniles. Mark Duke, for example, murdered his father for refusing to loan him a truck, and his father's girlfriend and her 2 young daughters because he wanted no witnesses of the crime. He shot his father and his father's girlfriend point blank in the face as they pleaded for their lives. He then tracked the girls down in their hiding places and slit their throats, leaving them alive for several minutes as they drowned in their own blood. Whatever one's views on the permissibility or wisdom of the death penalty, I doubt anyone would disagree that each of these crimes was egregious enough to merit the severest condemnation that society has to offer. The only constitutional problem with the fact that these criminals were spared that condemnation while others were not is that their amnesty came in the form of unfounded claims. Arbitrariness has nothing to do with it. To the extent that we are ill at ease with these disparate outcomes, it seems to me that the best solution is for the court to stop making up Eighth Amendment claims in its ceaseless quest to end the death penalty through undemocratic means. So generally, Thomas agrees with the outcome of this case, but he goes further to say that he believes the Eighth Amendment prohibits punishments that are designed to induce unnecessary pain or indignify the inmate on purpose. He thinks that Glossip's argument would fall flat on its face on that point alone, and he also dedicates the bulk of his opinion to addressing a point made by Justice Stephen Breyer, which is that the death penalty in its present form does not serve its original purpose of condemning the worst criminals in the strongest ways possible. Thomas refutes this by basically just talking about inmates who have been executed and all of the horrific crimes they committed leading to their execution. He then says that those criminals who committed egregious crimes, who were spared the death penalty, were only spared because the court tried to make what he calls unfounded claims in order to abolish the death penalty through undemocratic means, which is a fairly harsh criticism coming from a Supreme Court judge. Not only did Justice Scalia join this concurring opinion, but he wrote his own separate concurrence to which Justice Thomas joined. That concurrence reads as follows: I join the opinion of the court and write to respond to Justice Breyer's plea for judicial abolition of the death penalty. Welcome to Groundhog Day. The scene is familiar. Petitioners sentenced to die for the crimes they committed, including in the case of one petitioner since put to death, raping and murdering an 11-month-old baby, come before this court asking us to nullify their sentences as cruel and unusual under the Eighth Amendment. They rely on this provision because it is the only provision they can rely on. They were charged by a sovereign state with murder. They were afforded counsel and tried before a jury of their peers, tried twice, once to determine whether they were guilty and once to determine whether death was the appropriate sentence. They were duly convicted and sentenced. They were granted the right to appeal and to seek post-conviction relief, first in state and then in federal court, and now acknowledging that their convictions are unassailable, they ask us for clemency, as though clemency were ours to give. The response is also familiar, a vocal minority of the court waving over their heads a ream of the most recent abolitionist studies, a superabundant genre, as though they have discovered the lost folios of Shakespeare, insist that now, at long last, the death penalty must be abolished for good. Mind you, not once in the history of the American Republic has the court ever suggested that the death penalty is categorically impermissible. The reason is obvious. It is impossible to hold unconstitutional that which the Constitution explicitly contemplates. The Fifth Amendment provides that no person shall be held to answer for a capital crime unless on a presentment or indictment of a grand jury, and that no person shall be deprived of life without due process of the law. Nevertheless, today Justice Breyer takes on the role of the abolitionists in this long-running drama, arguing that the text of the Constitution and 2 centuries of history must yield to his 20 years of experience on this court, and inviting full briefing on the continued permissibility of capital punishment. Historically, the Eighth Amendment was understood to bar only those punishments that added terror, pain, or disgrace to an otherwise permissible capital sentence. Rather than bother with this troubling detail, Justice Breyer elects to contort the constitutional text. Redefining cruel to mean unreliable, arbitrary, or causing excessive delays, and unusual to include a decline in use, he proceeds to offer up a white paper devoid of any meaningful legal argument. Even accepting Justice Breyer's rewriting of the Eighth Amendment, his argument is full of internal contradictions and, it must be said, gobbledygook. He says that the death penalty is cruel because it is unreliable, but it is convictions, not punishments, that are unreliable. Moreover, the pressure on police, prosecutors, and jurors to secure a conviction, which he claims increases the risk of wrongful convictions in capital cases, flows from the nature of the crime, not the punishment that allows its commission. Justice Breyer acknowledges as much. The crimes at issue in capital cases are typically horrendous murders and thus accompanied by intense community pressure. That same pressure would exist and the same risk of wrongful convictions if horrendous death penalty cases were converted into equally horrendous life without parole cases. The reality is that any innocent defendant is infinitely better off appealing a death sentence than a sentence of life imprisonment, which again, Justice Breyer acknowledges. Quote, courts or state governors are 130 times more likely to exonerate a defendant where a death sentence is at issue. The capital convict will obtain endless legal assistance from the abolition lobby and legal favoritism from abolitionist judges, while the lifer languishes unnoticed behind bars. Justice Breyer next says that the death penalty is cruel because it is arbitrary. To prove this point, he points to a study of 205 cases that, quote, measure the egregiousness of the murderer's conduct with a system of metrics, unquote, and then compared the egregiousness of the conduct of the 9 defendants sentenced to death with the egregiousness of the conduct of defendants in the remaining 196 cases who were not sentenced to death. If only Aristotle, Aquinas, and Hume knew that moral philosophy could be so neatly distilled into a pocket-sized vade-mecum system of metrics. Of course it cannot. Egregiousness is a moral judgment susceptible of few hard and fast rules. More importantly, egregiousness of the crime is only one of several factors that render a punishment condign. Culpability, rehabilitative potential, and the need for deterrence also are relevant. That is why this court has required an individualized consideration of all mitigating circumstances, rather than formulaic application of some egregiousness test. It is because these questions are contextual and admit of no easy answers that we rely on juries to make judgments about the people and crimes before them. The fact that these judgments may vary across cases is an inevitable consequence of the jury trial, that cornerstone of Anglo-American judicial procedure. But when a punishment is authorized by law, if you kill, you are subject to death, the fact that some defendants receive mercy from their jury no more renders the underlying punishment cruel than does the fact that some guilty individuals are never apprehended, are never tried, are never acquitted, or are pardoned. Justice Breyer's third reason that the death penalty is cruel is that it entails delay, thereby 1. Subjecting inmates to long periods on death row, and 2. Undermining the penological justifications of the death penalty. The first point is nonsense. Life without parole is an even lengthier period than the wait on death row, and if the objection is that death row is a more confining environment, the solution should be modifying the environment rather than abolishing the death penalty. As for the argument that delay undermines the penological rationales for the death penalty, in insisting that the major alternative to capital punishment, namely life in prison without possibility of parole, also incapacitates, Justice Breyer apparently forgets that one of the plaintiffs in this very case was already in prison when he committed the murder that landed him on death row. Justice Breyer further asserts that whatever interest in retribution might be served by the death penalty as currently administered, that interest can be served almost as well by a sentence of life in prison without parole. My goodness, if he thinks the death penalty not much more harsh and hence not much more retributive, why is he so keen to get rid of it? With all due respect, whether the death penalty and life imprisonment constitute more or less equivalent retribution is a question far above the judiciary's pay grade. Perhaps Justice Breyer is more forgiving or more enlightened than those who, like Kant, believed that death is the only just punishment for taking a life. I would not presume to tell parents whose life has been forever altered by the brutal murder of a child that life imprisonment is punishment enough. And finally, Justice Breyer speculates that it does not seem likely that the death penalty has a significant deterrent effect. It seems very likely to me, and there are statistical studies that say so, but we federal judges live in a world apart from the vast majority of Americans. After work, we retire to homes in placid suburbia or to high-rise co-ops with guards at the door. We are not confronted with the threat of violence that is ever present in many Americans' everyday lives. The suggestion that the incremental deterrent effect of capital punishment does not seem significant reflects, it seems to me, a let-them-eat-cake obliviousness to the needs of others. Let the people decide how much incremental deterrence is appropriate. Of course, this delay is a problem of the court's own making. As Justice Breyer concedes, for more than 160 years, capital sentences were carried out in an average of 2 years or less. But by 2014, he tells us it took an average of 18 years to carry out a death sentence. What happened in the intervening years? Nothing other than the proliferation of labyrinth restrictions on capital punishment promulgated by this court under an interpretation of the Eighth Amendment that empowered it to divine the evolving standards of decency that mark the progress of a maturing society, a task which we are eminently ill-suited. Indeed, for the past 2 decades, Justice Breyer has been the drum major in this parade. His invocation of the resultant delay as grounds for abolishing the death penalty calls to mind the man sentenced to death for killing his parents, who pleads for mercy on the ground that he is an orphan. Amplifying the surrealism of this argument, Justice Breyer uses the fact that many states have abandoned capital punishment, have abandoned it precisely because of the costs those suspect decisions have imposed, to conclude that it is now unusual. A caution to the reader: do not use the creative arithmetic that Justice Breyer employs in counting the number of states that use the death penalty when you prepare your next tax return. Outside the world of our Eighth Amendment abolitionist-inspired jurisprudence, it will be regarded as more misrepresentation than math. If we were to travel down the path that Justice Breyer sets out for us and once again consider the constitutionality of the death penalty, I would ask that counsel also brief whether our cases that have abandoned the historical understanding of the Eighth Amendment, beginning with Trope, should be overruled. That case has caused more mischief to our jurisprudence, to our federal system, and to our society than any other that comes to mind. Justice Breyer's dissent is the living refutation of Trope's assumption that this court has the capacity to recognize evolving standards of decency. Time and again, the people have voted to exact the death penalty as punishment for the most serious crimes. Time and again, this court has upheld that decision, and time and again, a vocal minority of this court has insisted that things have changed radically and has sought to replace the judgments of the people with their own standards of decency. Capital punishment presents moral questions that philosophers, theologians, and statesmen have grappled with for millennia. The framers of our Constitution disagreed bitterly on the matter. For that reason, they handled it the same way that they handled many other controversial issues. They left it to the people to decide. By arrogating to himself the power to overturn that decision, Justice Breyer does not just reject the death penalty, he rejects the Enlightenment. Antonin Scalia concurs in the judgment of the majority and criticizes Stephen Breyer's arguments against the death penalty perhaps more harshly than even Justice Thomas. Scalia calls Breyer's efforts to dismantle capital punishment an abandonment of the Enlightenment-era thought that resulted in the Founding Fathers installing certain safeguards in the Constitution that would allow it to be changed should the country's views on the topic change. Scalia argues that if the death penalty is really as bad as Breyer says it is, then the Constitution should be amended to outlaw it. Until then, Scalia believes that the state has a right to effectuate death sentences and that this process should not be impeded unless the death sentence would involve a method of execution designed to create excessive terror or pain. Moreover, Scalia chastises Breyer's criticism that the death penalty is handed out arbitrarily. Scalia argues that the fact that some horrific criminals are sentenced to death while others are given lighter sentences is not an indicator of the arbitrariness of the death penalty. Rather, it is proof that the criminals and the context in which their crimes occur are often much more nuanced and complicated than Breyer leads the reader to believe. For that reason, Scalia says, the imposition rests upon a jury or of the criminal defendant's peers, members of the community who can more accurately judge the egregiousness of the actions committed than a judge who is simply handed a sheet of paper with a bulleted list of case facts. Finally, in his dissent, which we will get to soon enough, Breyer argues that the often years-long delay that occurs between a sentence and an execution is cruel enough to constitute a violation of the Eighth Amendment. Scalia openly accuses Breyer and other abolitionist judges as being to blame for these delays, as they often hand down opinions that force states to either abandon or change their execution protocol, and these changes can greatly prolong the time it takes for a death row inmate to meet their end. Thomas and Scalia both level heavy criticisms of Justice Breyer's dissent, but Justice Sotomayor also filed a dissent that did not receive nearly as much flack. That dissent, joined by Justices Ginsburg, Breyer, and Kagan, reads as follows. Petitioners, 3 inmates on Oklahoma's death row, challenged the constitutionality of the state's lethal injection protocol. The state plans to execute petitioners using 3 drugs, midazolam, rocuronium bromide, and potassium chloride. The latter 2 drugs are intended to paralyze the inmate and stop his heart, but they do so in a torturous manner, causing burning, searing pain. It is thus critical that the first drug, midazolam, do what it is supposed to do, which is to render and keep the inmate unconscious. Petitioners claim that midazolam cannot be expected to perform that function, and they have presented ample evidence showing that the state's planned use of this drug poses substantial, constitutionally intolerable risks. Nevertheless, the court today turns aside petitioners' plea that they at least be allowed a stay of execution while they seek to prove midazolam's inadequacy. The court achieves this result in 2 ways. First, by deferring to the district court's decision to credit the scientifically unsupported and implausible testimony of a single expert witness, and second, by faulting petitioners for failing to satisfy the wholly novel requirement of proving the availability of an alternative means for their own executions. On both counts, the court errs. As a result, it leaves petitioners exposed to what may well be the chemical equivalent of being burned alive at the stake. The Eighth Amendment succinctly prohibits the infliction of cruel and unusual punishments. 7 years ago, in Bays v. Rees, the court addressed the application of this mandate to Kentucky's lethal injection protocol. At the time, Kentucky, like at least 29 of the 35 other states with the death penalty, utilized a series of 3 drugs to perform executions. Sodium thiopental, a fast-acting barbiturate sedative that induces a deep coma-like unconsciousness when given in the amounts used for lethal injection, pancuronium bromide, a paralytic agent that inhibits all muscular skeletal movements and stops respiration, and potassium chloride, which interferes with the electrical signals that stimulate the contractions of the heart, inducing cardiac arrest. In Bays, it was disputed that, absent a proper dose of sodium thiopental, there would be a substantial, constitutionally unacceptable risk of suffocation from the administration of pancuronium bromide and pain from the injection of potassium chloride. That is because, if given to a conscious inmate, pancuronium bromide would leave him or her asphyxiated and unable to demonstrate any outward sign of distress, while potassium chloride would cause excruciating pain. But the Bayes petitioners conceded that if administered as intended, Kentucky's method of execution would nevertheless result in a humane death, as the proper administration of sodium thiopental eliminates any meaningful risk that a prisoner would experience pain from the subsequent injections of pancuronium bromide and potassium chloride. Based on that premise, the court ultimately rejected the challenge of Kentucky's protocol, with the plurality opinion concluding that the state's procedures for administering these three drugs ensured there is no objectively intolerable risk of severe pain. For many years, Oklahoma performed executions using the same three drugs at issue in Bayes. After Bayes was decided, however, the primary producer of sodium thiopental refused to continue permitting the drug to be used in executions. Like a number of other states, Oklahoma opted to substitute pentobarbital, another barbiturate, in its place. But in March 2014, shortly before two scheduled executions, Oklahoma found itself unable to secure this drug. The state rescheduled the executions for the following month to give time to locate an alternative anesthetic. In less than a week, a group of officials from the Oklahoma Department of Corrections and the Attorney General's office selected midazolam to serve as a replacement for pentobarbital. Soon thereafter, Oklahoma used midazolam for the first time in its execution of Clayton Lockett. That execution did not go smoothly. 10 minutes after an intravenous line was set in Lockett's groin area and 100 milligrams of midazolam were administered, an attending physician declared Lockett unconscious. When the paralytic and potassium chloride were administered, however, Lockett awoke. Various witnesses reported that Lockett began to writhe against his restraints, saying, "This shit is fucking with my mind. Something is wrong, and the drugs aren't working." State officials ordered the blinds lowered, then halted the execution. But 10 minutes later, approximately 40 minutes after the execution began, Lockett was pronounced dead. The state stayed all future executions while it sought to determine what had gone wrong in Lockett's. 5 months later, the state released an investigative report identifying the flaw in the IV line as the principal difficulty. The IV had failed to fully deliver the lethal drugs into Lockett's veins. An autopsy determined, however, that the concentration of midazolam in Lockett's blood was more than sufficient to render an average person unconscious. In response to this report, the state modified its lethal injection protocol. The new protocol contains a number of procedures designed to guarantee that members of the execution team are able to insert the IV properly, and charges them with ensuring that the inmate is unconscious. But the protocol continues to authorize the use of the same three-drug formula used to kill Lockett, though it does increase the intended dose of midazolam from 100 to 500 milligrams. The state has indicated that it plans to use this drug combination in all upcoming executions, subject to only an immaterial substitution of paralytic agents. In June 2014, inmates on Oklahoma's death row filed a suit against respondent prison officials challenging the constitutionality of Oklahoma's method of execution. After the state released its revised execution protocol, the four inmates whose executions were most imminent, Charles Warner, along with petitioners Richard Glossip, John Grant, and Benjamin Cole, moved for a preliminary injunction. They contended, among other things, that the state's intended use of midazolam would violate the Eighth Amendment because, unlike sodium thiopental or pentobarbital, the drug is incapable of producing a state of unawareness that will be reliably maintained after either of the two pain-producing drugs is injected. The district court held a 3-day evidentiary hearing, at which petitioners relied principally on the testimony of two experts, Dr. David Lubarsky, an anesthesiologist, and Dr. Larry Sasek, a doctor of pharmacy. The state, in turn, based its case on the testimony of Dr. Roswell Evans, also a doctor of pharmacy. To a great extent, the experts' testimony overlapped. All three experts agreed that midazolam is from a class of sedative drugs known as benzodiazepines, a class that includes Valium and Xanax, and that it has no analgesic or pain-relieving effects. They further agreed that while midazolam can be used to render someone unconscious, it is not approved by the FDA for use as, and is not in fact used as, a sole drug to produce and maintain anesthesia in surgical proceedings. Finally, all three experts recognized that midazolam is subject to a ceiling effect, which means that there is some point at which increasing the dose of the drug does not result in any greater effect. The experts' opinions diverged, however, on the crucial questions of how this ceiling effect operates and whether it will prevent midazolam from keeping a condemned inmate unconscious when the second and third lethal injection drugs are administered. Dr. Lubarsky testified that while benzodiazepines such as midazolam may, like barbiturate drugs such as sodium thiopental and pentobarbital, induce unconsciousness by inhibiting neuron function, they do so in a materially different way. More specifically, Dr. Lubarsky explained that both barbiturates and benzodiazepines initially cause sedation by facilitating the binding of a naturally occurring chemical called GABA with GABA receptors, which then impedes the flow of electrical impulses through the neurons in the central nervous system. But at higher doses, barbiturates also act as a GABA substitute and mimic its neuron-suppressing effects. By contrast, benzodiazepines lack this mimicking function, which means their effect is capped at a lower level of sedation. Critically, according to Dr. Lubarsky, this ceiling on midazolam's sedative effect is reached before full anesthesia can be achieved. Thus, in his view, while midazolam unconsciousness is sufficient for minor procedures, it is incapable of keeping someone insensate and immobile in the face of more noxious stimuli, including the extreme pain and discomfort associated with administration of the second and third drugs in Oklahoma's lethal injection protocol. Dr. Sasek endorsed Dr. Lubarsky's description of the ceiling effect and other similar reasons for reaching the same conclusion. In support of these assertions, both experts cited a variety of evidence. Dr. Lubarsky emphasized in particular Arizona's 2014 execution of Joseph Wood, which had been conducted using midazolam and the drug hydromorphone rather than the three-drug cocktail Oklahoma intends to employ. Despite being administered 750 milligrams of midazolam, Wood had continued breathing and moving for nearly 2 hours, which, according to Dr. Lubarsky, would not have occurred during extremely deep levels of anesthesia. Both experts also cited various scientific articles and textbooks to support their conclusions. For instance, Dr. Lubarsky relied on a study measuring the brain activity of rats that were administered midazolam, which showed that the drug's impact significantly tailed off at higher doses. He also pointed to a pharmacology textbook that confirmed his description of how benzodiazepines and barbiturates produce their effect, and a survey article concluding that midazolam cannot be used alone to maintain adequate anesthesia. For his part, Dr. Sasek referred to a separate survey article which similarly recognized and described the ceiling effect to which benzodiazepines are subject. By contrast, Dr. Evans, the state's expert, asserted that the 500 milligram dose of midazolam would render the person unconscious and insensate during the remainder of the execution procedure. He rested his conclusion on two interrelated propositions. First, observing that a therapeutic dose of midazolam to treat anxiety is less than 5 milligrams for a 70-kilogram adult, Dr. Evans emphasized that Oklahoma's planned administration of 500 milligrams of the drug was at least 100 times the normal therapeutic dose. While he acknowledged that there were no studies that have been done administering that much midazolam to anybody, he noted that deaths had occurred in doses as low as 0.04 to 0.07 milligrams per kilogram, and contended that a 500 milligram dose would itself cause death within less than an hour, a conclusion he characterized as essentially an extrapolation from a toxic effect. Second, in explaining how he reconciled his opinion with the evidence of midazolam's ceiling effect, Dr. Evans testified that while GABA receptors are found across the entire body, midazolam's ceiling effect is limited to the spinal cord, and there is no ceiling effect at the higher level of the brain. Consequently, in his view, as you increase the dose of midazolam, it's a linear effect, so you're going to continue to get an impact from higher doses of the drug until eventually you're paralyzing the brain. Dr. Evans also understood the chemical source of midazolam's ceiling effect somewhat differently from petitioner's experts. Although he agreed that midazolam produces its effect by binding to GABA receptors, he appeared to believe that midazolam produced sedation by inhibiting GABA from attaching to GABA receptors, not by promoting GABA's sedative effects. Thus, when asked about Dr. Lubarsky's description of the ceiling effect, Dr. Evans characterized the phenomenon as stemming from the competitive nature of substances trying to attach to GABA receptors. Dr. Evans cited no scholarly research in support of his opinions. Instead, he appeared to rely primarily on two sources, the website drugs.com and a material safety data sheet produced by a midazolam manufacturer. Both simply contained general information that covered the experts' area of agreement. The district court denied petitioner's motion for a preliminary injunction. It began by making a series of factual findings regarding the characteristics of midazolam and its use in Oklahoma's execution protocol. Most relevant here, the district court found that the proper administration of 500 milligrams of midazolam would make it a virtual certainty that an individual will be at a sufficient level of unconsciousness to resist the noxious stimuli which could occur from the application of the second and third drugs. Respecting petitioners' contention that there is a ceiling effect which prevents an increase in a dosage from having a corresponding incremental effect on anesthetic depth, the district court concluded, Dr. Evans testified persuasively that whatever the ceiling effect of midazolam may be with respect to anesthesia, which takes effect at the spinal cord level, there is no ceiling effect with respect to the ability of a 500 milligram dose of midazolam to effectively paralyze the brain, a phenomenon which is not anesthesia but does have the effect of shutting down respiration and eliminating the individual's awareness of pain. Having made these findings, the district court held that petitioners had shown no likelihood of success on the merits of their Eighth Amendment claim for two independent reasons. First, it determined that petitioners had failed to establish that proceeding with their executions on the basis of the revised protocol presents an objectively intolerable risk of harm. Second, the district court held that petitioners were unlikely to prevail because they had not identified any known and available alternative means by which they could be executed, a requirement it understood Bayes to impose. The district court concluded that the state had affirmatively shown that sodium thiopental and pentobarbital, the only alternatives to which the petitioners had even alluded, are not available to the state. The Court of Appeals for the Tenth Circuit affirmed. It, like the district court, held that petitioners were unlikely to prevail on the merits because they had failed to prove the existence of known and available alternatives. In any event, the court concluded it was unable to conclude that the district court's factual findings had been clearly erroneous, and thus petitioners had also failed to establish that the use of midazolam in their executions creates a demonstrated risk of severe pain. Petitioners and Charles Warner filed a petition for certiorari and an application to stay their executions. The court denied the stay application, and Charles Warner was executed on January 15, 2015. The court subsequently granted certiorari and, at the request of the state, stayed petitioners' pending executions. I begin with the second of the court's two holdings, that the district court properly found that petitioners did not demonstrate a likelihood of showing that Oklahoma's execution protocol poses an unconstitutional risk of pain. In reaching this case, the court sweeps aside substantial evidence showing that while midazolam may be able to induce unconsciousness, it cannot be utilized to maintain unconsciousness in the face of agonizing stimuli. Instead, like the district court, the court finds comfort in Dr. Evans's wholly unsupported claims that 500 milligrams of midazolam will paralyze the brain. In so holding, the court disregards an objectively intolerable risk of severe pain. Like the court, I would review for clear error the district court's findings that 500 milligrams of midazolam will render someone sufficiently unconscious to resist the noxious stimuli which could occur from the application of the second and third drugs. Unlike the court, however, I would do so without abdicating our duty to examine critically the factual predicates for the district court's findings, namely Dr. Evans's testimony that midazolam has a ceiling effect only at the spinal cord level, and that a 500 milligram dose of midazolam can therefore effectively paralyze the brain. To be sure, as the court observes, such scientific testimony may at times lie at the boundaries of federal courts' expertise, but just because a purported expert says something does not make it so. Especially when important constitutional rights are at stake, federal district courts must carefully evaluate the premises and evidence on which scientific conclusions are based, and appellate courts must ensure that the courts below have in fact carefully considered all the evidence presented. Clear error exists when, although there is evidence to support a finding, the reviewing court on the entire evidence is left with the definite and firm conviction that a mistake has been committed. Here, given the numerous flaws in Dr. Evans's testimony, there can be little doubt that the district court clearly erred in relying on it. To begin, Dr. Evans identified no scientific literature to support his opinion regarding midazolam's properties at a higher than normal dose. Apart from a material safety data sheet that was relevant only insofar as it suggests that a low dose of midazolam may occasionally be toxic, an issue I discuss further below, Dr. Evans's testimony seems to have been based on the website drugs.com. The court may be right that petitioners do not identify any incorrect statement from drugs.com on which Dr. Evans relied, but that is because there are no statements from drugs.com that supported the critically disputed aspects of Dr. Evans's opinion. If anything, the website supported petitioners' contentions as it expressly cautioned that midazolam should not be used alone for maintenance of anesthesia, and contained no warning that the excessive dose of midazolam could paralyze the brain. More importantly, nothing from drugs.com or for that matter any other source in the record, corroborated Dr. Evans's key testimony that midazolam's sealing effect is limited to the spinal cord and does not pertain to the brain. Indeed, the state appears to have disavowed Dr. Evans's spinal cord theory, refraining from even mentioning it in its brief, despite the fact that the district court expressly relied on this testimony as the basis for finding that larger doses of midazolam will have greater anesthetic effects. The court likewise assiduously avoids defending this theory. That is likely because this aspect of Dr. Evans's testimony was not just unsupported, but was directly refuted by the studies and articles cited by Drs. Lubarsky and Sasek. Both of these experts relied on academic texts describing benzodiazepine's sealing effect and explaining why it prevents these drugs from rendering a person completely insensate. One study further made clear that the sealing effect is apparent in the brain. These scientific sources also appeal to demonstrate that Dr. Evans's spinal cord theory, i.e. that midazolam's sealing effect is limited to the spinal cord, was premised on a basic misunderstanding of midazolam's mechanism in action. I say appear not because the sources themselves are unclear about how midazolam operates. They plainly state that midazolam functions by promoting GABA's inhibitory effects on the central nervous system. Instead, I use appear because discerning the rationale underlying Dr. Evans's testimony is difficult. His spinal cord theory might, however, be explained at least in part by his apparent belief that rather than promoting GABA's inhibitory effects, midazolam produces sedation by competing with GABA and thus inhibiting GABA's effect. Regardless, I need not delve too deeply into Dr. Evans's alternative scientific reality. It suffices to say that to the extent that Dr. Evans's testimony was based on his understanding of the source of midazolam's pharmacological properties, that understanding was wrong. These inconsistencies and inaccuracies go to the very heart of Dr. Evans's expert opinion, as they were the key components of his professed belief that one can extrapolate from what is known about midazolam's effect at low doses to conclude that the drug would paralyze the brain at Oklahoma's planned dose. All three experts recognized that there had been no scientific testing on the use of this amount of midazolam in conjunction with these particular lethal injection drugs. For this reason, as the court correctly observes, extrapolation was reasonable, but simply because extrapolation may be reasonable or even required does not mean that every conceivable method of extrapolation can be credited, or that all estimates stemming from purported extrapolation are worthy of belief. Dr. Evans's view was that because 40 milligrams of midazolam could be used to induce unconsciousness, and because more drug will generally produce more effect, a significantly larger dose of 500 milligrams would not just induce unconsciousness but allow for its maintenance in the face of extremely painful stimuli, and ultimately even cause death itself. In his words, quote, "As you increase the dose of midazolam, it's a linear effect, so you're going to continue to get an impact from higher doses of the drug," unquote. If, however, there is a ceiling effect with respect to midazolam's effect on the brain, as petitioners' experts establish there is, then such simplistic logic is not viable. In this context, more is not necessarily better, and Dr. Evans was plainly wrong to assume that it would be. If Dr. Evans had any other basis for the extrapolation that led him to conclude that 500 milligrams of midazolam would paralyze the brain, it is even further divorced from scientific evidence and logic. Having emphasized that midazolam had been known to cause approximately 80 deaths, Dr. Evans asserted that his opinion regarding the efficacy of Oklahoma's planned use of the drug represented essentially an extrapolation from a toxic effect. Thus, Dr. Evans appeared to believe, and again I say appeared because his rationale is not clear, that because midazolam caused some deaths, it would necessarily cause complete unconsciousness and then death at especially high doses. But Dr. Evans also thought, and Dr. Lubarsky confirmed, that these midazolam fatalities had occurred at very low doses, well below what any expert said would produce unconsciousness. These deaths thus seem to represent the rare unfortunate side effects that one would expect to see with any drug at normal therapeutic doses. They provide no indication of the effect one would expect midazolam to have on the brain at substantially higher doses. Deaths occur with almost any product. One might as well say that because some people occasionally die from eating one peanut, 100 peanuts would necessarily induce a coma and death in anyone. In sum, then, Dr. Evans's conclusions were entirely unsupported by any study or third-party source, contradicted by the extrinsic evidence proffered by petitioners, inconsistent with the scientific understanding of midazolam's property, and apparently premised on basic logical errors. Given these glaring flaws, the district court's acceptance of Dr. Evans's claim that 500 milligrams of midazolam would paralyze the brain cannot be credited. This is not a case where there are two permissible views of the evidence and the district court chose one. Rather, it is one where the trial judge credited one or two or more witnesses, even though that witness failed to tell a coherent and facially plausible story that is not contradicted by extrinsic evidence. In other words, this is a case in which the district court clearly erred. Setting aside the district court's erroneous factual findings that 500 milligrams of midazolam will necessarily paralyze the brain, the question is whether the court is nevertheless correct to hold that petitioners failed to demonstrate that the use of midazolam poses an objectively intolerable risk of severe pain. I would hold that they made this showing. That is because, in stark contrast to Dr. Evans, petitioners as experts were able to point to objective evidence indicating that midazolam cannot serve as an effective anesthetic that renders a person insensate to pain caused by the second and third lethal injection drugs. As noted above, these experts cited multiple sources supporting the existence of midazolam's ceiling effect. That evidence alone provides ample reason to doubt midazolam's efficacy. Again, to prevail on their claim, petitioners need only to establish an intolerable risk of pain, not a certainty. Here, the state is attempting to use midazolam to produce an effect that the drug has never previously been demonstrated to produce, and despite studies indicating that at some point increasing the dose will not actually increase the drug's effect, the state is thus proceeding in the face of a very real risk that the drug will not work in the manner it claims. Moreover, and perhaps more importantly, the record provides good reason to think that this risk is substantial. The court insists that petitioners failed to provide probative evidence as to whether midazolam's ceiling effect occurs below the level of a 500 milligram dose and at a point at which the drug does not have the effect of rendering a person insensate to pain. It emphasizes that Dr. Lubarsky was unable to say at what dose the ceiling effect occurs and could only estimate that it was probably after about 40 to 50 milligrams. But the precise dose at which midazolam reaches its ceiling effect is irrelevant if there is no dose at which the drug can, in the court's words, render a person insensate to pain. On this critical point, Dr. Lubarsky was quite clear. He explained that the drug does not work to produce a lack of consciousness as noxious stimuli are applied, and is not sufficient to produce a surgical plane of anesthesia in human beings. He also noted that the drug would never be used and has never been used as the sole anesthetic to give anesthesia during a surgery, and asserted that the drug was not approved by the FDA as a sole anesthetic because after the use of fairly large doses that were sufficient to reach the ceiling effect and produce induction of unconsciousness, the patients responded to the surgery. Thus, Dr. Lubarsky may not have been able to identify whether this effect would be reached at 40, 50, or 60 milligrams or some higher threshold, but he could specify that at no level would midazolam reliably keep an inmate unconscious once the second and third drugs were delivered. These assertions were amply supported by the evidence of the manner in which midazolam is and can be used. All three experts agreed that midazolam is utilized as the sole sedative only in minor procedures. Dr. Evans, for example, acknowledged that while midazolam may be used as the sole drug in some procedures that are not terribly invasive, even then, you would generally see it used in a combination with a narcotic. And though, as the court observes, Dr. Sasek believed midazolam could be used for medical procedures like colonoscopies and gastroscopies, he insisted that these procedures were not necessarily painful, and that it would be a big jump to conclude that midazolam would be effective to maintain unconsciousness throughout an execution. Indeed, the record provides no reason to think that these procedures cause excruciating pain remotely comparable to that produced by the second and third lethal injection drugs Oklahoma intends to use. As for more painful procedures, the consensus was also clear. Midazolam is not FDA approved for and is not used as the sole drug to maintain unconsciousness. One might infer from the fact that midazolam is not used as the sole anesthetic for more serious procedures that it cannot be used for them. But drawing such an inference is unnecessary, as petitioners' experts invoked sources expressly stating as much. In particular, Dr. Lubarsky pointed to a survey article that cited 4 separate authorities and declared that midazolam cannot be used alone to maintain adequate anesthesia. This evidence was alone sufficient, but if one wanted further support for these conclusions, it was provided by the Lockett and Wood executions. The procedural flaws that marred the Lockett execution created the conditions for an unintended and grotesque experiment on midazolam's efficacy. Due to problems with the IV line, Lockett was not fully paralyzed after the second and third drugs were administered. He had, however, been administered more than enough midazolam to render an average person unconscious, as the district court found. When Lockett awoke and began to writhe and speak, he demonstrated the critical difference between midazolam's ability to render an inmate unconscious and its ability to maintain the inmate in that state. The court insists that Lockett's execution involved only 100 milligrams of midazolam, but as previously explained, more is not necessarily better given midazolam's sealing effect. The Wood execution is perhaps even more probative. Despite being given over 750 milligrams of midazolam, Wood gasped and snorted for nearly 2 hours. These reactions were, according to Dr. Lubarsky, inconsistent with Wood being fully anesthetized, and believed the claim that a lesser dose of 500 milligrams would somehow suffice. The court attempts to distinguish the Wood execution on the ground that the timing of Arizona's administration of midazolam was different, but as Dr. Lubarsky testified, it did not matter whether in Wood's execution the midazolam was introduced all at once or over multiple doses, because the drug has a sufficient half-life that the effect is cumulative. Nor does the fact that Wood's dose of midazolam was paired with hydromorphone rather than a paralytic and potassium chromide appear to have any relevance, other than that the use of this analgesic drug may have meant that Wood did not experience the same degree of searing pain that an inmate executed under Oklahoma's protocol may face. By contrast, Florida's use of this same 3-drug protocol in 11 executions tells us virtually nothing. Although these executions have featured no obvious mishaps, the key word is obvious. Because the protocol involves the administration of a powerful paralytic, it is, as Dr. Sasek and Lubarsky explained, impossible to tell whether the condemned inmate in fact remained unconscious. Even in these executions, moreover, there have been indications of the inmate's possible awareness. Finally, none of the state's safeguards for administering these drugs would seem to mitigate the substantial risk that midazolam will not work, as the court contends. Protections ensuring that officials have properly secured a viable IV site will not enable midazolam to have an effect that it is chemically incapable of having. Nor is there any indication that the state's monitoring of the inmate's unconsciousness will be able to anticipate whether the inmate will remain unconscious while the second and third drugs are administered. No one questions whether midazolam can induce unconsciousness. The problem, as Lockett's execution vividly illustrates, is that an unconscious inmate may be awakened by the pain and respiratory distress caused by administration of the second and third drugs. At that point, even if it were possible to determine whether the inmate is unconscious, dubious given the use of a paralytic, it is already too late. Presumably for these reasons, the Tenth Circuit characterized the district court's reliance on these procedural mechanisms as not relevant to its rejection of petitioners' claims regarding the inherent characteristics of midazolam. The court not only disregards this record evidence of midazolam's inadequacy, but also fails to fully appreciate the procedural posture in which this case arises. Petitioners have not been accorded a full hearing on the merits of their claim. They were granted only an abbreviated evidentiary hearing that began less than 3 months after the state issued its amended execution protocol. They did not even have the opportunity to present rebuttal evidence after Dr. Evans testified. They sought a preliminary injunction and thus were not required to prove their claim, but only to show that they were likely to succeed on the merits. Perhaps the state could prevail after a full hearing, though this would require more than Dr. Evans's unsupported testimony. At the preliminary injunction stage, however, petitioners presented compelling evidence suggesting that midazolam will not work as the state intends. The state, by contrast, offered absolutely no contrary evidence worth crediting. Petitioners are thus, at the very least, likely to prove that due to midazolam's inherent deficiencies, there is a constitutionally intolerable risk that they will be awake yet unable to move while chemicals known to cause excruciating pain course through their veins. The court's determination that the use of midazolam poses no objectively intolerable risk of severe pain is factually wrong. The court's conclusion that petitioners' challenge also fails because they identify no available alternative means by which the state may kill them is legally indefensible. This court has long recognized that certain methods of execution are categorically off limits. The court first confronted an Eighth Amendment challenge to a method of execution in Wilkerson v. Utah. Although Wilkerson approved the particular method at issue, the firing squad, it made clear that public dissection, burning alive, and other punishments of torture in the same line of unnecessary cruelty are forbidden by the Eighth Amendment to the Constitution. 11 years later, in rejecting a challenge to the first proposed use of the electric chair, the court again reiterated that if the punishment prescribed for an offense against the laws of the state were manifestly cruel and unusual, such as burning at the stake, crucifixion, breaking on the wheel, or the like, it would be the duty of the courts to adjudge such penalties to be within constitutional prohibition. In the more than a century since, the members of this court have often had cause to debate the full scope of the Eighth Amendment's prohibition of cruel and unusual punishment.
but there has been little dispute that it at the very least precludes the imposition of barbarous physical punishments, nor has there been any question that the amendment prohibits such inherently barbaric punishments under all circumstances. Simply stated, the Eighth Amendment categorically prohibits the infliction of cruel and unusual punishments. The court today, however, would convert this categorical prohibition into a conditional one, a method of execution that is intolerably painful, even to the point of being the chemical equivalent of burning alive, will the court holds will be unconstitutional if and only if there is a known and available alternative method of execution. It deems Bayes to foreclose any argument to the contrary. Bayes held no such thing. In the first place, the court cites only the plurality opinion in Bayes as support for its known and available alternative requirement. Even assuming the Bayes plurality set forth such a requirement, which it did not, none of the members of the court whose concurrences were necessary to sustain the Bayes court's judgment articulated a similar view. In general, the holding of the court may be viewed as that position taken by those members who concurred in the judgments on the narrowest grounds, and as the court observes, the opinion of Justice Thomas, joined by Justice Scalia, took the broadest position with respect to the degree of intent that state officials must have in order to have violated the Eighth Amendment, concluding that only a method of execution deliberately designed to inflict pain, and not one simply designed with deliberate indifference to the risk of severe pain, would be unconstitutional. But this understanding of the Eighth Amendment's intent requirement is unrelated to, and thus not any broader or narrower than, the requirement the court now divines from Bayes. Because the position that a plaintiff challenging a method of execution under the Eighth Amendment must prove the availability of an alternative means of execution did not represent the views of the majority of the court, it was not the holding of the Bayes court. In any event, even the Bayes plurality opinion provides no support for the court's proposition. To be sure, the opinion contains the following sentence: the condemned must show that the risk is substantial when compared to the known and available alternatives, but the meaning of that key sentence and the limits of the requirement it imposed are made clear by the sentence directly preceding it. A stay of execution may not be granted on the grounds such as those asserted here unless the condemned prisoner establishes that the state's lethal injection protocol creates a demonstrated risk of severe pain. In Bayes, the very premise of the petitioner's Eighth Amendment claim was that they had identified a significant risk of harm in Kentucky's protocol that could be eliminated by adopting alternative procedures. Their basic theory was that even if the risk of pain was only, say, 25%, that risk would be objectively intolerable if there was an obvious alternative that would reduce the risk to 5%. Thus, the grounds asserted for relief in Bayes were that the state's protocol was intolerably risky given the alternative procedures the state could have employed. Addressing this claim, the Bayes plurality clarified that a condemned prisoner cannot successfully challenge a state's method of execution merely by showing a slightly or marginally safer alternative. Instead, to succeed in a challenge of this type, the comparative risk must be substantial. Nowhere did the plurality suggest that all challenges to a state's method of execution would require this sort of comparative risk analysis. Recognizing the relevance of available alternatives is not at all the same as concluding that their absence precludes a claimant from showing that a chosen method carries objectively intolerable risks. If, for example, prison officials chose a method of execution that has a 99% chance of causing lingering and excruciating pain, certainly that risk would be objectively intolerable whether or not the officials ignored other methods in making its choice. Irrespective of the existence of alternatives, there are some risks so grave that it violates contemporary standards of decency to expose anyone unwillingly to them. That the Bayes plurality statements regarding a condemned inmate's ability to point to an available alternative means of execution pertained only to challenges premised on the existence of such alternatives is further evidenced by the opinion's failure to distinguish or even mention the court's unanimous decision in Hill v. McDonough. Hill held that a Section 1983 plaintiff challenging a state's method of execution need not identify an alternative authorized method of execution. True, as the court notes, Hill did so in the context of addressing Section 1983's pleading standard, rejecting the proposed alternative means requirement because the court saw no basis for the imposition of heightened pleading requirements. But that only confirmed that the court in Hill did not view the availability of an alternative means of execution as an element of an Eighth Amendment claim. If it had, then requiring the plaintiff to plead this element would not have meant imposing a heightened standard at all, but rather would have been entirely consistent with the traditional pleading requirements. The Bayes plurality opinion should not be understood to have so carelessly tossed aside Hill's underlying premise less than 2 years later. In re-engineering Bayes to support its newfound rule, the court appears to rely on a flawed syllogism. If the death penalty is constitutional, the court reasons that there must be a means of accomplishing it, and thus some available method of execution must be constitutional. But even accepting that the death penalty is in the abstract consistent with evolving standards of decency, the court's conclusion does not follow. The constitutionality of the death penalty may inform our conception of the degree of pain that would render a particular method of imposing it unconstitutional. Because some risk of pain is inherent in any method of execution, it is clear the Constitution does not demand the avoidance of all risk of pain. But a method of execution that is barbarous or involves torture or a lingering death does not become less so just because it is the only method currently available to a state. If all available means of conducting an execution constitute cruel and unusual punishment, then conducting the execution will constitute cruel and unusual punishment. Nothing compels a state to perform an execution. It does not get a constitutional free pass simply because it desires to deliver the ultimate penalty. Its ends do not justify any and all means. If a state wishes to carry out an execution, it must do so subject to the constraints that our Constitution imposes on it, including the obligation to ensure that its chosen method is not cruel and unusual. Certainly, the condemned has no duty to devise or pick a constitutional instrument of his or her own death. For these reasons, the court's available alternative requirement leads to patently absurd consequences. Petitioners contend that Oklahoma's current protocol is a barbarous method of punishment, the chemical equivalent of being burned alive. But under the court's new rule, it would not matter whether the state intended to use midazolam or instead to have petitioners drawn and quartered, slowly tortured to death, or actually burned at the stake. Because petitioners failed to prove the availability of sodium thiopental or pentobarbital, the state could execute them using whatever means it designated. The Eighth Amendment cannot possibly countenance such a result. In concocting this additional requirement, the court is motivated by a desire to preserve states' ability to conduct executions in the face of changing circumstances. It is true, as the court details, that states have faced practical obstacles to obtaining lethal injection drugs since Bayes was decided. One study concluded that recent years have seen states change their protocols with a frequency that is unprecedented among execution methods in this country's history. But why such developments compel the court's imposition of further burdens on those facing execution is a mystery. Petitioners here had no part in creating the shortage of execution drugs. It is odd to punish them for the actions of pharmaceutical companies and others who seek to dissociate themselves from the death penalty, actions which are, of course, wholly lawful. Nor certainly should these rapidly changing circumstances give us any greater confidence that the execution methods ultimately selected will be sufficiently humane to satisfy the Eighth Amendment. Quite the contrary. The execution protocol states hurriedly devise as they scramble to locate new and untested drugs are all the more likely to be cruel and unusual. Presumably, these drugs would have been the state's first choice were they in fact more effective. Courts' review of execution methods should be more, not less, searching when states are engaged in what is in effect human experimentation. It is also worth noting that some condemned inmates may read the court's surreal requirement that they identify the means of their death as an invitation to propose methods of executions less consistent with modern sensibilities. Petitioners have failed to meet the court's new test because of their assumption that the alternative drugs to which they pointed, pentobarbital and sodium thiopental, were available to the state. This was perhaps a reasonable assumption, especially given that neighboring Texas and Missouri still to this day continue to use pentobarbital in executions. In the future, however, condemned inmates might well decline to accept states' current reliance on lethal injection. In particular, some inmates may suggest the firing squad as an alternative. Since the 1920s, only Utah has utilized this method of execution, but there is evidence to suggest that the firing squad is significantly more reliable than other methods, including lethal injection, using the various combinations of drugs thus far developed. Just as important, there is some reason to think that it is relatively quick and painless. Certainly, use of the firing squad could be seen as a devolution to a more primitive era. That is not to say, of course, that it would therefore be unconstitutional. But lethal injection represents just the latest iteration of the state's centuries-long search for neat and non-disfiguring homicidal methods. A return to the firing squad and the blood and physical violence that comes with it is a step in the opposite directions, and some might argue that the visible brutality of such a death could conceivably give rise to its own Eighth Amendment concerns. At least from a condemned inmate's perspective, however, such visible yet relatively painless violence may be vastly preferable to an excruciatingly painful death hidden behind a veneer of medication. The states may well be reluctant to pull back the curtain for fear of how the rest of us might react to what we see. But we deserve to know the price of our collective comfort before we blindly allow a state to make condemned inmates pay it in our names. By protecting even those convicted of heinous crimes, the Eighth Amendment reaffirms the duty of the government to respect the dignity of all persons. Today, however, the court absolves the state of Oklahoma of this duty. It does so by misconstruing and ignoring the record evidence regarding the constitutional insufficiency of midazolam as a sedative in a 3-drug lethal injection cocktail, and by imposing a wholly unprecedented obligation on the condemned inmate to identify an available means of his or her own execution. The contortions necessary to save this particular lethal injection protocol are not worth the price. I dissent. So Justice Sotomayor's dissent focuses a lot on the district court's use of Dr. Evans' testimony. Dr. Evans is the medical expert used by the state, and he testified in district court that midazolam was sufficient at keeping an inmate anesthetized and incapacitated while the subsequent drugs took effect. He also testified as to the sealing effect of midazolam. His testimony was contrasted by Glossip's medical expert, who said nearly the exact opposite, that midazolam would not keep an inmate unconscious, and that the sealing effect operated in such a way that it doesn't matter if an inmate received 100 milligrams or 500 milligrams of midazolam, they would still experience the pain of the other 2 lethal injection drugs. She also criticized the majority for imposing an additional burden on death row inmates that would force them to present an alternative method of execution. Justice Sotomayor was not the only one to file a dissent, however. Justice Breyer also wrote a dissenting opinion, which you have already seen received a lot of attention from the majority. That opinion, which was joined by Justice Ginsburg, reads as follows. For the reasons stated in Justice Sotomayor's opinion, I dissent from the court's holding. But rather than try to patch up the death penalty's legal wounds one at a time, I would ask for a full briefing on a more basic question, whether the death penalty violates the Constitution. The relevant legal standard is the standard set forth in the Eighth Amendment. The Constitution there forbids the infliction of cruel and unusual punishments. The court has recognized that a claim that punishment is excessive is judged not by the standards that prevailed in 1685 when Lord Jeffreys presided over the bloody assizes or when the Bill of Rights was adopted, but rather by those that currently prevail. Indeed, the Constitution prohibits various gruesome punishments that were common in Blackstone's day. Nearly 40 years ago, this court upheld the death penalty under statutes that, in the court's view, contained safeguards sufficient to ensure that the penalty would be applied reliably and not arbitrarily. The circumstances and the evidence of the death penalty's application have changed radically since then. Given those changes, I believe that it is now time to reopen the question. In 1976, the court thought that the constitutional infirmities in the death penalty could be healed. The court, in effect, delegated significant responsibility to the states to develop procedures that would protect against those constitutional problems. Almost 40 years of studies, surveys, and experience strongly indicate, however, that this effort has failed. Today's administration of the death penalty involves 3 fundamental constitutional defects. 1. Serious unreliability. 2. Arbitrariness in application. And 3. Unconscionably long delays that undermine the death penalty's penological purpose. Perhaps as a result, 4. Most places within the United States have abandoned its use. I shall describe each of these considerations, emphasizing changes that have occurred during the past 4 decades. For it is those changes, taken together with my own 20 years of experience on this court, that lead me to believe that the death penalty, in and of itself, now likely constitutes a legally prohibited, cruel, and unusual punishment. This court has specified that the finality of death creates a qualitative difference between the death penalty and other punishments, including life in prison. That qualitative difference creates a corresponding difference in the need for reliability in the determination that death is the appropriate punishment in a specific case. There is increasing evidence, however, that the death penalty, as now applied, lacks that requisite reliability. For one thing,
Despite the difficulty of investigating the circumstances surrounding an execution for a crime that took place long ago, researchers have found convincing evidence that in the past 3 decades, innocent people have been executed. For another, the evidence that the death penalty has been wrongly imposed, whether or not it was carried out, is striking. As of 2002, this court used the word disturbing to describe the number of instances in which individuals had been sentenced to death but later exonerated. At that time, there was evidence of approximately 60 exonerations in capital cases. Since 2002, the number of exonerations in capital cases has risen to 115. Last year, in 2014, 6 death row inmates were exonerated based on actual innocence. All had been imprisoned for more than 30 years, and one for almost 40 years at the time of their exonerations. The stories of the 3 men exonerated within the last year are illustrative. DNA evidence showed that Henry Lee McCullum did not commit the rape and murder for which he had been sentenced to death. Last term, this court ordered that Anthony Ray Hinton, who had been convicted of murder, receive further hearings in state court. He was exonerated earlier this year because the forensic evidence used against him was flawed, and when Glenn Ford, also convicted of murder, was exonerated, the prosecutor admitted that even, quote, at the time this case was tried, there was evidence that would have cleared Glenn Ford, unquote. All 3 of these men spent 30 years on death row before being exonerated. Furthermore, criminal exonerations occur far more frequently where capital convictions rather than ordinary criminal convictions are at issue. Researchers have calculated that courts or state governors are 130 times more likely to exonerate a defendant where a death sentence is at issue. They are 9 times more likely to exonerate where a capital murder rather than a non-capital murder is at issue. Why is that so? To some degree, it must be because the law that governs capital cases is more complex. To some degree, it must reflect the fact that courts scrutinize capital cases more closely, but to some degree, it likely also reflects a greater likelihood of an initial wrongful conviction. How could that be so? In the view of researchers who have conducted these studies, it could be so because the crimes at issue in capital cases are typically horrendous murders and thus accompanied by intense community pressure on police, prosecutors, and jurors to secure a conviction. This pressure creates a greater likelihood of convicting the wrong person. In the case of Cameron Todd Willingham, for example, who, as noted earlier, was executed despite likely innocence, the State Bar of Texas recently filed formal misconduct charges against the lead prosecutor for his actions that may have contributed to Willingham's conviction. And in the Glenn Ford's case, the prosecutor admitted that he was partly responsible for Ford's wrongful conviction, issuing a public apology to Ford and explaining that at the time of Ford's conviction, he was, quote, not as interested in justice as he was in winning, unquote. Other factors may also play a role. One is the practice of death qualification. No one can serve on a capital jury who is not willing to impose the death penalty. Another is the more general problem of flawed forensic testimony. The Federal Bureau of Investigation, for example, recently found that flawed microscopic hair analysis was used in 33 of 35 capital cases under review. 9 of the 33 had already been executed. In light of these and other factors, researchers estimate that about 4% of those sentenced to death are actually innocent. Finally, if we expand our definition of exoneration, which we limited to errors suggesting the defendant was actually innocent, and thereby also categorize as erroneous instances in which courts failed to follow legally required procedures, the numbers soar. Between 1973 and 1995, courts identified prejudicial errors in 68% of the capital cases before them. State courts on direct and post-conviction review overturned 47% of the sentences they reviewed. Federal courts reviewing capital cases in habeas corpus proceedings found error in 40% of those cases. This research and these figures are likely controversial. Full briefing would allow us to scrutinize them with more care. But at a minimum, they suggest a serious problem of reliability. They suggest that there are too many instances in which courts sentence defendants to death without complying with the necessary procedures, and they suggest that in a significant number of cases, the death sentence is imposed on a person who did not commit the crime. Unlike 40 years ago, we now have plausible evidence of unreliability that, perhaps due to DNA evidence, is stronger than the evidence we had before.
In some, there is significantly more research-based evidence today indicating that courts sentence to death individuals who may well be actually innocent or whose convictions, in the law's view, do not warrant the death penalty's application. The arbitrary imposition of punishment is the antithesis of the rule of law. For that reason, Justice Potter Stewart, who supplied critical votes for the holdings in Furman v. Georgia, found the death penalty unconstitutional as administered in 1972. These death sentences are cruel and unusual in the same way that being struck by lightning is cruel and unusual. For of all the people convicted of death-eligible crimes, many, just as responsible as these petitioners are among a capriciously selected random handful upon which the sentence of death has in fact been imposed. When the death penalty was reinstated in 1976, this court acknowledged that the death penalty is and would be unconstitutional if inflicted in an arbitrary and capricious manner. The court has consequently sought to make the application of the death penalty less arbitrary by restricting its use to those whom Justice Souter called the worst of the worst. Despite the Gregg Court's hope for a fair administration of the death penalty, 40 years of further experience make it increasingly clear that the death penalty is imposed arbitrarily, i.e., without the reasonable consistency legally necessary to reconcile its use with the Constitution's commands. Thorough studies of death penalty sentences support this conclusion. A recent study, for example, examined all death penalty sentences imposed between 1973 and 2007 in Connecticut, a state that abolished the death penalty in 2012. The study reviewed treatment of all homicide defendants. It found 205 instances in which Connecticut law made the defendant eligible for a death sentence. Courts imposed a death sentence in 12 of these 205 cases, of which 9 were sustained on appeal. This study then measured the egregiousness of the murderer's conduct in those 9 cases, developing a system of metrics designed to do so. It then compared the egregiousness of the conduct of the 9 defendants sentenced to death with the egregiousness of the conduct of defendants in the remaining 196 cases, those in which the defendant, though found guilty of a death-eligible offense, was ultimately not sentenced to death. Application of the study's metrics made clear that only one of those 9 defendants was indeed the worst of the worst, or was at least within the 15% considered most egregious. The remaining 8 were not. Their behavior was no worse than the behavior of at least 33 and as many as 170 other defendants, out of a total pool of 205 who had not been sentenced to death. Such studies indicate that the factors that most clearly ought to affect the application of the death penalty, namely, comparative egregiousness of the crime, often do not. Other studies show that circumstances that ought not to affect application of the death penalty, such as race, gender, or geography, often do. Numerous studies, for example, have concluded that individuals accused of murdering white victims as opposed to black or other minority victims are more likely to receive the death penalty. Fewer but still many studies have found that the gender of the defendant or the gender of the victim makes a not otherwise warranted difference. Geography also plays an important role in determining who is sentenced to death, and that is not simply because some states permit the death penalty while others do not. Rather, within the death penalty state, the imposition of the death penalty heavily depends on the county in which a defendant is tried. Between 2004 and 2009, for example, just 29 counties, fewer than 1% of the counties in the country, accounted for approximately half of all death sentences imposed nationwide, and in 2012, just 59 counties, fewer than 2% of the counties in the country, accounted for all death sentences imposed nationwide. What accounts for this county-by-county disparity? Some studies indicate that the disparity reflects the decision-making authority, the legal discretion, and ultimately the power of the local prosecutor. Others suggest that the availability of resources for defense counsel, or the lack thereof, helps explain geographical differences. Still others indicate that the racial composition of and distribution within a county plays an important role. Finally, some studies suggest that political pressures, including pressures on judges who must stand for election, can make a difference. Thus, whether one looks at research indicating that irrelevant or improper factors such as race, gender, local geography, and resources do significantly determine who receives the death penalty, or whether one looks at research indicating that proper factors such as egregiousness do not determine who receives the death penalty, the legal conclusion must be the same. The research strongly suggests that the death penalty is imposed arbitrarily. Justice Thomas catalogs the tragic details of various capital cases, but this misses my point. Every murder is tragic, but unless we return to the mandatory death penalty struck down in Woodson, the constitutionality of capital punishment rests on its limited application to the worst of the worst, and this extensive body of evidence suggests that it is not so limited. 4 decades ago, the court believed it impossible to interpret the Eighth Amendment in ways that would significantly limit the arbitrary application of the death sentence, but that no longer seems likely. The Constitution does not prohibit the use of prosecutorial discretion. It has not proved possible to increase capital defense funding significantly, and courts cannot easily inquire into judicial motivation. Moreover, racial and gender biases may unfortunately reflect deeply rooted community biases, conscious or unconscious, which, despite their legal irrelevance, may affect a jury's evaluation of mitigating evidence. Nevertheless, it remains the jury's task to make the individualized assessment of whether the defendant's mitigation evidence entitles him to mercy. Finally, since this court held that comparative proportionality review is not constitutionally required, it seems unlikely that appeals can prevent the arbitrariness I have described. The studies bear out my own view, reached after considering thousands of death penalty cases and last-minute petitions over the course of more than 20 years. I see discrepancies for which I can find no rational explanations. Why does one defendant who committed a single victim murder receive the death penalty due to aggravators of a prior felony conviction and an after-the-fact robbery, while another defendant does not, despite having kidnapped, raped, and murdered a young mother while leaving her infant baby to die at the scene of the crime? Why does one defendant who committed a single victim murder receive the death penalty due to aggravators of a prior felony conviction and acting recklessly with a gun, while another defendant does not, despite having committed a triple murder by killing a young man, and his pregnant wife? For that matter, why does one defendant who participated in a single victim murder-for-hire scheme plus an after-the-fact robbery receive the death penalty, while another defendant does not, despite having stabbed his wife 60 times and killed his 6-year-old daughter and 3-year-old son while they slept? In each instance, the sentences compared were imposed in the same state at about the same time. The question raised by these examples, and the many more I could give but do not, as well as by the research to which I have referred, is the same question Justice Stewart, Justice Powell, and others raised over the course of several decades. The imposition and implementation of the death penalty seems capricious, random, indeed arbitrary. From a defendant's perspective, to receive that sentence and certainly to find it implemented is the equivalent of being struck by lightning. How then can we reconcile the death penalty with the demands of a constitution that first and foremost insists upon a rule of law? The problems of reliability and unfairness almost inevitably lead to a third independent constitutional problem: excessively long periods of time that individuals typically spend on death row, alive but under sentence of death. That is to say, delay is in part a problem that the Constitution's own demands create. Given the special need for reliability and fairness in death penalty cases, the Eighth Amendment does and must apply to the death penalty with special force. Those who face that most severe sanction must have a fair opportunity to show that the Constitution prohibits their execution. At the same time, the Constitution insists that every safeguard be observed when a defendant's life is at stake. These procedural necessities take time to implement, and unless we abandon the procedural requirements that assure fairness and reliability, we are forced to confront the problem of increasingly lengthy delays in capital cases. Ultimately, though these legal causes may help to explain, they do not mitigate the harms caused by the delay itself. Consider first the statistics. In 2014, 35 individuals were executed. Those executions occurred on average nearly 18 years after a court initially pronounced its sentence of death. In some death penalty states, the average delay is longer. In an oral argument last year, for example, the state admitted that the last 10 prisoners executed in Florida had spent an average of nearly 25 years on death row before execution. The length of the delay has increased dramatically over the years. In 1960, the average delay between sentencing and execution was 2 years. 10 years ago, in 2004, the average delay was about 11 years. By last year, the average had risen to about 18 years. Nearly half of the 3,000 inmates now on death row have been there for more than 15 years, and at present execution rates, it would take more than 75 years to carry out those 3,000 death sentences. Thus, the average person in death row would spend an additional 37.5 years before being executed. I cannot find any reasons to believe this trend will soon be reversed. These lengthy delays create two special constitutional deficiencies. First, a lengthy delay in and of itself is especially cruel because it subjects death row inmates to decades of especially severe, dehumanizing conditions of confinement. Second, lengthy delay undermines the death penalty's penological rationale. Turning to the first constitutional difficulty, nearly all death penalty states keep death row inmates in isolation for 22 or more hours per day. This occurs even though the ABA has suggested that death row inmates be housed in conditions similar to the general population, and the United Nations Special Rapporteur on Torture has called for the global ban on solitary confinement longer than 15 days. And it is well documented that such prolonged solitary confinement produces numerous deleterious harms. The dehumanizing effect of solitary confinement is aggravated by uncertainty as to whether a death sentence will in fact be carried out. In 1890, this court recognized that when a prisoner sentenced by a court to death is confined in the penitentiary awaiting the execution of the sentence, one of the most horrible feelings to which he can be subjected during that time is the uncertainty during the whole of it. The court was there describing a delay of a mere 4 weeks. In the past century and a quarter, little has changed in this respect except for the duration. Today we must describe delays measured not in weeks but in decades. Moreover, we must consider death warrants that have been issued and revoked not once but repeatedly. Several inmates have come within hours or days of execution before later being exonerated. Willie Manning was 4 hours from his scheduled execution before the Mississippi Supreme Court stayed the execution. 2 years later, Manning was exonerated after the evidence against him, including flawed testimony from an FBI hair examiner, was severely undermined. Furthermore, given the negative effects of confinement and uncertainty, it is not surprising that many inmates volunteer to be executed, abandoning further appeals. Indeed, one death row inmate who was later exonerated still said he would have preferred to die rather than to spend years on death row pursuing his exoneration. Others have written at great length about the constitutional problems that delays create, and rather than repeat their facts, arguments, and conclusions, I simply refer to some of their writings. The second constitutional difficulty resulting from lengthy delays is that those delays undermine the death penalty's penological rationale, perhaps irreparably so. The rationale for capital punishment, as for any punishment, classically rests upon society's need to secure deterrence, incapacitation, retribution, or rehabilitation. Capital punishment by definition does not rehabilitate. It does, of course, incapacitate the offender, but the major alternative to capital punishment, namely life in prison without possibility of parole, also incapacitates. Thus, as the court has recognized, the death penalty's penological rationale in fact rests almost exclusively upon a belief in its tendency to deter and upon its ability to satisfy a community's interest in retribution. Many studies have examined the death penalty's deterrent effect. Some have found such an effect, whereas others have found a lack of evidence that it deters crime. Recently, the National Research Council, whose members are drawn from the councils of the National Academy of Sciences, the National Academy of Engineering, and the Institute of Medicine, reviewed 30 years of empirical evidence and concluded that it was insufficient to establish a deterrent effect and thus should not be used to inform discussion about the deterrent value of the death penalty. I recognize that a lack of evidence for a proposition does not prove the contrary, but suppose that we add to these studies the fact that today very few of those sentenced to death are actually executed, and that even those executions occur on average after nearly 2 decades on death row. Then does it still seem likely that the death penalty has a significant deterrent effect? Consider, for example, what actually happened to the 183 inmates sentenced to death in 1978. As of 2013, 35 years later, 38 or 21% of them had been executed. 132 or 72% had had their convictions or sentence overturned or commuted, and 7 or 4% had died of other natural causes. 6 remained on death row. The example illustrates a general trend. Of the 8,466 inmates under a death sentence at some point between 1973 and 2013, 16% were executed. 42% had their convictions or sentences overturned or commuted, and 6% died by other causes. The remainder are still on death row. Thus, an offender who is sentenced to death is 2 or 3 times more likely to find his sentence overturned or commuted than to be executed, and he has a good chance of dying from natural causes before any execution or exoneration can take place. In a word, executions are rare, and an individual contemplating a crime but evaluating the potential punishment would know that, in any event, he faces a potential sentence of life without parole. These facts, when recurring, must have some offsetting effect on a potential perpetrator's fear of a death penalty, and even if that effect is no more than slight, it makes it difficult to believe, given the studies of deterrence cited earlier, that such a rare event significantly deters horrendous crimes. But what about retribution? Retribution is a valid penological goal. I recognize that surviving relatives of victims of a horrendous crime, or perhaps the community itself, may find vindication in an execution, and the community that favors the death penalty has an understandable interest in representing their voices. The relevant question here, however, is whether a community's sense of retribution can often find vindication in a death that comes, if at all, only several decades after the crime was committed. By then, the community is a far different group of people. The offenders and the victims' family have grown far older. Feelings of outrage may have subsided. The offender may have found himself a changed human being, and sometimes repentance and even forgiveness can restore meaning to lives once ruined. At the same time, the community and victims' families will know that even without a further death, the offender will serve decades in prison under a sentence of life without parole. I recognize, of course, that this may not always be the case, and that sometimes the community believes that an execution could provide closure. Nevertheless, the delays and low probability of execution must play some role in any calculation that leads a community to insist on death as retribution. As I have already suggested, they may well attenuate the community's interest in retribution to the point where it cannot by itself amount to a significant justification for the death penalty. In any event, I believe that whatever interest in retribution might be served by the death penalty as currently administered, that interest can be served almost as well by a sentence of life in prison without parole. Finally, the fact of lengthy delays undermines any effort to justify the death penalty in terms of its prevalence when the founders wrote the Eighth Amendment. When the founders wrote the Constitution, there were no 20 or 30-year delays. Execution took place soon after sentencing, and for reasons I shall describe, we cannot return to the quick executions in the founding era. The upshot is that lengthy delays both aggravate the cruelty of the death penalty and undermine its jurisprudential rationale. And this court has said that if the death penalty does not fulfill the goals of deterrence or retribution, it is nothing more than the purposeless and needless imposition of pain and suffering, and hence an unconstitutional punishment. Indeed, Justice Lewis Powell, who provided a crucial vote in Gregg, came to much the same conclusion, albeit after his retirement from the court. Justice Powell had come to the court convinced that the federal Constitution did not outlaw the death penalty, but rather left the matter up to individual states to determine. Soon after Justice Powell's retirement, Chief Justice Rehnquist appointed him to chair a committee addressing concerns about delays in capital cases, the Ad Hoc Committee on Federal Habeas Corpus in Capital Cases. The committee presented a report to Congress, and Justice Powell testified that delay robs the penalty of much of its deterrent value. Justice Powell, according to his official biographer, ultimately concluded that capital punishment, quote, serves no useful purpose. The United States was unique among the industrialized nations of the West in maintaining the death penalty, and it was enforced so rarely that it could not deter. More important, the haggling and delay and seemingly endless litigation in every capital case brought the law itself into disrepute, unquote. In short, the problem of excessive delays led Justice Powell, at least in part, to conclude that the death penalty was unconstitutional. As I have said, today's delays are much worse. When Chief Justice Rehnquist appointed Justice Powell to the committee, the average delay between sentencing and execution was 7 years and 11 months, compared with 17 years and 7 months today. One might ask, why can Congress or the states not deal directly with the delay problem? Why can they not take steps to shorten the time between sentence and execution and thereby mitigate the problems just raised? The answer is that shortening delay is much more difficult than one might think, and that is in part because efforts to do so risk causing procedural harms that also undermine the death penalty's constitutionality. For one thing, delays have helped to make the application of the death penalty more reliable. Recall the case of Henry Lee McCollum, whom DNA evidence exonerated 30 years after his conviction. If McCollum had been executed earlier, he would not have lived to see the day when DNA evidence exonerated him and implicated another man. That man is already serving a life sentence for a rape and murder that he committed just a few weeks after the murder McCollum was convicted of. In fact, this court had earlier denied review of McCollum's claim over the public dissent of only one justice, and yet a full 20 years after the court denied review, McCollum was exonerated by DNA evidence. There are a significant number of similar cases, some of which I have discussed earlier. In addition to those who are exonerated on the grounds that they are innocent, there are other individuals whose sentences or convictions have been overturned for other reasons. As discussed above, state and federal courts found error in 68% of capital cases they reviewed between 1973 and 1995. In many of these cases, a court will have found that the individual did not merit the death penalty in a special sense, namely, he failed to receive all the procedural protections that the law requires for the death penalty's application. By eliminating some of these protections, one likely could reduce delay. But which protections should we eliminate? Should we eliminate the trial-related protections we have established for capital defendants, that they be able to present to the sentencing judge or jury all mitigating circumstances, that the state provide guidance adequate to reserve the application of the death penalty to particularly serious murders, that the state provide adequate counsel and, where warranted, adequate expert assistance, or that a jury must find the aggravating factors necessary to impose the death penalty? Should we no longer ensure that the state does not execute those who are seriously intellectually disabled? Should we eliminate the requirement that the manner of executions be constitutional, or the requirement that the inmate be mentally competent at the time of his execution? Or should we get rid of the criminal protections that all criminal defendants receive? For instance, that defendants claiming violation of constitutional guarantees, say due process of law, may seek a writ of habeas corpus in federal courts? My answer to these questions is surely not. One might, of course, argue that courts, particularly federal courts providing additional layers of review, apply these and other requirements too strictly, and that causes delay. But it is difficult for judges, as it would be difficult for anyone, not to apply legal requirements punctiliously when the consequence of failing to do so may well be death, particularly the death of an innocent person. Moreover, review by courts at every level helps to ensure reliability. If this court had not ordered that Anthony Ray Hinton receive further hearings in state court, he may well have been executed rather than exonerated. In my own view, our legal system's complexity, our federal system with its separate state and federal courts, our constitutional guarantees, our commitment to fair procedure, and above all, a special need for reliability and fairness in capital cases combine to make significant procedural reform unlikely in practice to reduce delays to an acceptable level. And that fact creates a dilemma. A death penalty system that seeks procedural fairness and reliability brings with it delays that severely aggravate the cruelty of capital punishment and significantly undermine the rationale for imposing a sentence of death in the first place. But a death penalty system that minimizes delays would undermine the legal system's efforts to secure reliability and procedural fairness. In this world, or at least in this nation, we can have a death penalty that at least arguably serves legitimate penological purposes, or we can have a procedural system that at least arguably seeks reliability and fairness in the death penalty's application. We cannot have both. And that simple fact, demonstrated convincingly over the past 40 years, strongly supports the claim that the death penalty violates the Eighth Amendment. A death penalty system that is unreliable or procedurally unfair would violate the Eighth Amendment. And so would a system that, if reliable and fair in its application of the death penalty, would serve no legitimate penological purpose. The Eighth Amendment forbids punishments that are cruel and unusual. Last year, in 2014, only 7 states carried out an execution. Perhaps more importantly, in the last 2 decades, the imposition and implementation of the death penalty have increasingly become unusual. I can illustrate the significant decline in the use of the death penalty in several ways. An appropriate starting point concerns the trajectory of the number of annual death sentences nationwide from the 1970s to present day. In 1977, just after the Supreme Court made clear that, by modifying their legislation, states could reinstate the death penalty, 137 people were sentenced to death. Many states having revised their death penalty laws to meet Furman's requirements, the number of death sentences then increased. Between 1986 and 1999, 286 persons on average were sentenced to death each year, but approximately 15 years ago the numbers began to decline, and they have declined rapidly ever since. In 1999, 279 persons were sentenced to death. Last year, just 73 persons were sentenced to death. That trend, a significant decline in the past 15 years, also holds true with respect to the number of annual executions. In 1999, 98 people were executed. Next, one can consider state-level data. Often when deciding whether a punishment practice is constitutionally speaking unusual, this court has looked to the number of states engaging in that practice. In this respect, the number of active death penalty states has fallen dramatically. In 1972, when the court decided Furman, the death penalty was lawful in 41 states. 9 states had abolished it. As of today, 19 states have abolished the death penalty, along with the District of Columbia. In 11 other states that maintain the death penalty on the books, no execution has taken place for more than 8 years. Arkansas, California, Colorado, Kansas, Montana, Nevada, New Hampshire, North Carolina, Oregon, Pennsylvania, and Wyoming. Accordingly, 30 states have either formally abolished the death penalty or have not conducted an execution in more than 8 years. Of the 20 states that have conducted at least one execution in the past 8 years, 9 have conducted fewer than 5 in that time, making an execution in those states a fairly rare event. That leaves 11 states in which it is fair to say that capital punishment is not unusual. And just 3 of those states, Texas, Missouri, and Florida, accounted for 80% of the executions nationwide in 2014. Indeed, last year only 7 states conducted an execution. In other words, in 43 states no one was executed. In terms of population, if we ask how many Americans live in a state that at least occasionally carries out an execution, at least one within the prior 3 years, the answer 2 decades ago was 60% or 70%. Today, that number is 33%. At the same time, use of the death penalty has become increasingly concentrated geographically. County by county figures are relevant for decisions to impose the death penalty typically take place at a county level. County-level sentencing figures show that between 1973 and 1997, 66 of America's 3,143 counties accounted for approximately half of all death sentences imposed. By the early 2000s, the death penalty was only actively practiced in a very small number of counties. Between 2004 and 2009, only 35 counties imposed 5 or more death sentences, i.e. approximately 1 per year, and more recent data show that the practice has diminished yet further. Between 2010 and 2015, only 15 counties imposed 5 or more death sentences. In short, the number of active death penalty counties is small and getting smaller, and the overall statistics on county-level executions bear this out. Between 1976 and 2007, there were no executions in 86% of America's counties. In sum, if we look to the states, in more than 60%, there is effectively no death penalty. In an additional 18%, an execution is rare and unusual, and 6%, i.e. 3 states, account for 80% of all executions. If we look to population, about 66% of the nation lives in a state that has not carried out an execution in the last 3 years, and if we look to counties, in 86% there is effectively no death penalty. It seems fair to say that it is now unusual to find capital punishment in the United States, at least when we consider the nation as a whole. Moreover, we have said that it is not so much the number of these states that is significant, but the consistency of the direction of change. Judged in that way, capital punishment has indeed become unusual. 7 states have abolished the death penalty in the last decade, including, quite recently, Nebraska. 11 states, as noted earlier, have not executed anyone in 8 years, and several states have formally stopped executing inmates. Moreover, the direction of change is consistent. In the past 2 decades, no state without a death penalty has passed legislation to reinstate the death penalty. Indeed, even in many states most associated with the death penalty, remarkable shifts have occurred. In Texas, the state that carries out the most executions, the number of executions fell from 40 in 2000 to 10 in 2014, and the number of death sentences fell from 48 in 1999 to 9 in 2013. These circumstances perhaps reflect the fact that a majority of Americans, when asked to choose between the death penalty and life in prison without parole, now choose the latter. I rely primarily upon domestic, not foreign events in pointing to changes in circumstances that tend to justify the claim that the death penalty constitutionally speaking, is unusual. Those circumstances are sufficient to warrant our reconsideration of the death penalty's constitutionality. I note, however, that many nations, indeed 95 of the 193 members of the United Nations, have formally abolished the death penalty, and an additional 42 have abolished it in practice. In 2013, only 22 countries in the world carried out an execution. No executions were carried out in Europe or Central Asia, and the United States was the only country in the Americas to execute an inmate in 2013. Only 8 countries executed more than 10 individuals: the United States, China, Iran, Iraq, Saudi Arabia, Somalia, Sudan, and Yemen. And almost 80% of all known executions took place in 3 countries: Iran, Iraq, and Saudi Arabia. I recognize a strong counter-argument that favors constitutionality. We are a court. Why should we not leave the matter up to the people acting democratically through legislatures? The Constitution foresees a country that will make the most important decisions democratically. Most nations that have abandoned the death penalty have done so through legislation, not judicial decision, and legislators, unlike judges, are free to take account of matters such as monetary costs, which I do not claim are relevant here. The answer is that the matters I have discussed, such as a lack of reliability, the arbitrary application of a serious and irreversible punishment, individual suffering caused by long delays, and lack of penological purposes, are quintessentially judicial matters. They concern the infliction, indeed the unfair, cruel, and unusual infliction, of a serious punishment upon an individual. I recognize that in 1972, this court, in a sense, turned to Congress and the state legislatures in its search for standards that would increase the fairness and reliability of imposing a death penalty. The legislatures responded, but in the last 4 decades, considerable evidence has accumulated that those responses has not worked. Thus, we are left with a judicial responsibility. The Eighth Amendment sets forth the relevant law, and we must interpret the law. For the reasons I have set forth in this opinion, I believe it highly likely that the death penalty violates the Eighth Amendment. At the very least, the court should call for a full briefing on this basic question. With respect, I dissent. Those remarks conclude Justice Breyer's dissent. Justice Breyer argues that examining the modern-day death penalty under modern-day standards convinced him that the death penalty is unconstitutionally cruel and unusual. Justice Breyer infamously points to a handful of studies which attempt to enumerate the egregiousness of crimes committed by those on death row, for which he was lambasted by the majority. He also identifies countless inmates who were executed and subsequently exonerated on new evidence as support for his argument that it is cruel and unusual. After all, he says, the death penalty is society's harshest condemnation of a criminal action, and it should not be imposed unless it is known practically for certain that the defendant did it. The fact that so many have been posthumously exonerated does not sit right with Justice Breyer. He also brings up an interesting paradox, which is that in order to safeguard defendants from being executed on scant evidence, there are lengthy appeals processes and procedural obligations to be fulfilled. These processes, however, create such a delay in the execution process that inmates ended up spending their lives in prison, whereas death row inmates were executed within weeks of their sentencing during the nation's infancy. He argues that these lengthy delays themselves constitute cruelty, but the only way to remedy the delays would be to get rid of the safeguards, which risks prosecutors seeking the death penalty more aggressively than they should. Justice Breyer says that currently we can either have a death penalty that is cruel because of its delays or cruel because of its wanton imposition, but either way it will be cruel. In his final argument regarding the unusualness of the death penalty, Justice Breyer finds that the decreasing number of states executing prisoners and the decreasing number of death sentences being handed out is enough to render the death penalty unconstitutionally unusual. So in the end, the Supreme Court sided with Oklahoma and concluded that its 3-drug protocol did not violate the Eighth Amendment. What became of Richard Glossip then? Well, I have to be honest, I have rewritten this part of the script several times because I started writing this in December of 2021, and there have been several developments in Glossip's case since then. On February 23, 2022, after spending 24 years on death row, Oklahoma lawmakers announced that they would be working with an international law firm in order to re-examine his case. Throughout this entire ordeal, Glossip has maintained his innocence. Glossip's conviction rested largely on the testimony of Justin Sneed, who claimed he was hired by Richard Glossip to kill Barry Van Treese. Glossip claims that Sneed was addicted to meth and would regularly burglarize homes and cars. Glossip's team also emphasized the fact that Sneed's testimony was given as part of a deal that would spare Sneed himself from the death penalty. As of writing this script, which is August 14th, 2022, Richard Glossip's execution date is slated for September 22nd, 2022. On August 12th, 2022, Glossip's counsel petitioned the state for clemency. Okay, never mind. This part of the script is being recorded on December 31st, 2022, and new developments have occurred. On November 2nd, 2022, Oklahoma's Governor Kevin Stitt stayed Glossip's execution until December 8th, 2022, and has since further stayed it until February 2023. So as of this edit being made, Richard Glossip has not been executed, but is scheduled to be executed in February 2023. As for the precedent set by this case, the precedent of Glossip merged with the precedent of Bays v. Rees to form what is known as the Bays-Glossip test, which I mentioned in the first episode of this podcast when I covered Bucklew v. Precythe. The precedent set in Bays v. Rees was that the Eighth Amendment does not prohibit an inmate from experiencing any pain at all. In other words, executions come with an inherent level of pain. An inmate challenging a method of execution must prove that the method of execution will bring about an unacceptable level of pain. The precedent set in Glossip was that an inmate challenging a method of execution must also identify a readily available alternative to that method of execution. So all in all, an inmate challenging their execution must prove that the way they are going to be executed will bring about an unacceptable level of pain, and they must identify a readily available alternative. That's the end of this episode of the On The Docket Podcast. Thank you so much for listening. I hope you enjoyed, and if you did, please consider subscribing, liking the video, and sharing it with anyone who might be interested. As for next week, since I already mentioned the precedent it's set, I will just spoil it now and say that the next episode will be covering Bays v. Rees.